21, 24 is somebody else. Okay, you finish your what? Arthur? I'm here to critique. What's it in that? You are in which item? 40? Okay. We'll see when the matter comes.
For for Maharshi, item number 43.
Yes, what is this I for? Which appearing? Item number 44,
Item number 43.
43. Yes, madam, what is your stand? Hmm. No, but the question of his pension is the subject matter of the writ petition. No, once he gets regularized, then only the question of pension will come. So that being at stake, the question of allowing this interlocutory application at this stage does not arise. To do one day notice, file your reply, but you do not even file. You do one thing, you have it again on Friday, and petitioner is not represented, we discuss. Okay. None appears on behalf of the petitioner on call, where so appears on behalf of the on the state of Nagaland. It has been taken note of that on the earlier occasions also the petitioner has not been represented. Under such circumstances, for the ends of justice, the matter stands adjourned to be listed again on 7/6/2024. It is made clear that if the petitioner is not represented on that date, this court shall dismiss the instant interlocutory application as
For motion, item number 44.
yes, who is there? Who is there? Why? Yes, madam. Who is appearing? Norman? Going to item number 9. You follow? Yes, you are there. Yes, my lord. You do one thing. Okay. Item number 9. Yeah, you have filed a case for compassionate appointment. No, your petition is for compassionate appointment.
Yes.
Now, you want to make the commissioner and secretary government of health and family department. This is an application. Who is the health and family welfare council? You are paying? You take your steps on the basis of the police. This is an application file for impleading the Commissioner and Secretary to the Government of Nagaland, Department of Health and Family Welfare, Kohima, Nagaland, as a party respondent to the instant proceedings. The need has arisen in view of a plea being taken by the respondents in their affidavit in opposition that the Commissioner and Secretary to the Government of Nagaland, Department of Health and Family Welfare, Kohima, Nagaland, is a necessary party to the instant proceedings. This court is of the opinion that under such circumstances, in the opinion of this court, the said party, the instant application is required to be allowed. Accordingly, the instant application is allowed by including the Commissioner and Secretary to the Government of Nagaland, Department of Health and Family Welfare, Kohima, Nagaland, as the respondent number 4 to the instant proceedings. The counsel appearing on behalf of the petitioner shall file a fresh memo of parties before the registry of this court by 7/6/2024, and on the basis of the same, along with the instant order, the registry shall make necessary correction in the records of the accompanying petition and also update the same in the CIS. I stands allowed. And in the main writ petition, Ms. So appears on behalf of the accepts notice on behalf of the newly impleaded respondent number 4. She further submits that she will take instruction as to whether the said newly impleaded respondent number 4 would like to file an affidavit in opposition. Accordingly, time granted for 2 weeks thereby fixing the on 27th of June 2024.
Plus,
Buta order, would it? I mean that.
For motion, item number 45.
This is linked with. Yes, what is this? I for Guwahati High Court?
this is for
Who is for Guwahati High Court?
I have for High Court.
You are a counsel for Guwahati High Court.
Yes, my lord.
What do you want?
One of impleadment in the pending writ petition. There is a writ petition which has been filed, and this is in relation to a bungalow, Your Lordship. And earlier there was a writ petition filed, came up before Your Lordship. Your Lordship referred the matter to the commissioner, directed the party to approach the commissioner.
I remember there was some order being passed. Yes, then
Then the commissioner has passed orders, and based on the commissioner's order, the deputy commissioner has cancelled the pata. After cancellation of the pata, the writ petition is again before his own court.
requisition challenging what?
That cancellation of the pata.
You don't have a board of revenue here?
No, my lord.
Where do you file an appeal against that order?
There is no board of revenue.
So, writ.
Yes, madam.
And against an appeal lies where?
You know,
He's taking steps against whom? Yes, you are appearing.
Yes, Lordship.
Yes, tell me.
Lordship, after the cancellation, the petitioner have filed the writ challenging, and this honorable court directed the petitioners to file appeal before the commissioner, Lordship. And so we have filed it. But however, the order that was passed, it was passed by the deputy commissioner, not by the, we have addressed the appeal before the commissioner. But however, the order, the cancellation order, or the cancellation of the pata order was issued by the deputy commissioner, Lordship. So on that angle,
Deputy Commissioner will
Yes,
only
Lordship.
cancel.
no, Lordship, here, the appeal, as per the order,
No. You filed an appeal against under section 12 before the
sir.
commissioner.
yes, Lordship.
That is a different aspect from making the what you call from challenging the order of cancellation of a patta. Cancellation of a patta is a different ball game. Whereby you see earlier, if I remember correctly, there was some order passed by me earlier, no?
Yes,
Yes.
Your
Yes.
Lordship.
Oh, yes. If I remember correctly, there was an option of filing an appeal. And therefore, I allowed you before the Commissioner, State of Nagaland. And the further direct that they shall maintain status quo as regards for a period of 15 days from today, and the petitioner herein would be at liberty to file application for stay of the operation of the impugn orders. So against that, you moved the Commissioner.
Yes, Lordship.
Has the Commissioner disposed of the appeal?
Your Lordship, here what happened, as per section 12, Lordship, section 12, subpara 5, clearly states that the appellate officer, Lordship, may, after hearing the appeal, Lordship, after hearing the appeal, confirm, modify, or reverse the order appeal from the Lordship. That is, but however, here, what happened was, we were never heard. We were never heard. The
Has he
petitioners,
passed
Lordship.
an order?
Your Lordship, here, my impugn is page number 52.
No, this is a different aspect.
Yes,
That is why
Lordship.
I'm saying. You see, the Deputy Commissioner initiated the proceedings under or through the estate officer initiated the proceedings under the Public Premises Act.
Agree, Your Lordship.
And on the basis thereof, an order was passed. Against that, you filed 2 writ petitions. The 2 writ petition, when it came before me, I said that there is an appellate provision, kindly go there, 15 days time I'm giving you, and asking the Commissioner also to consider your stay prayer.
Yes, Lordship.
Okay. That is as regards eviction. Now, one of your grounds of your eviction, not to evict you, is on the basis that you have a patta.
Yes.
Now the patta has been cancelled by the deputy commissioner, which is another aspect of the matter, which is different from the public premises proceedings. What that is why I'm asking, what did the commissioner do as regards your appeal? That appeal is still pending, isn't that?
That part I'm not aware.
No, isn't that the case?
Yes, sir.
Yes, because that is your appeal is still pending there. So under such circumstances, whether did you get a stay there? I even made it clear in my order that he will be entitled to so the petitioner herein would be at liberty to file appropriate application seeking stay of the operation of the impugned orders under section 12 Act of 1971. So did you get a stay there?
Yes, Lordship.
You got a stay.
I got a stay, Your Lordship.
So therefore the appeal is pending. But your cancellation of patta is a different aspect of the matter as to whether you have been legally granted a patta or not.
Lordship, here,
Now,
in the cancellation order, in the cancellation order.
let me,
I will-
you have the Assam Land Revenue,
Yes.
open it.
Unauthorized eviction act, Your Lordship, I have that.
So you have the settlement rules 26. Look into that. Because settlement rules 26 says when a patta can be cancelled. It says that a patta can be cancelled if the patta was issued in violation to the rules. So your entire case has to be on the basis thereof, because not on the ground of that public premises, because that appeal is still pending. So that has nothing to do here. Unless the appeal has been disposed of, which is not. Okay. We make them a party. So let you and me also become knowledgeable from him. Yes.
Lordship. Much obliged.
This is an application filed by the applicant seeking impleadment to the instant writ proceedings. On the ground that any order so passed in the instant writ proceedings would would affect the rights of the applicant. The learned counsel appearing on behalf of the petitioner, who is the opposite party herein, does not object to the instant application. Accordingly, this court therefore includes the Gauhati High Court, represented by its registrar, Gauhati High Court Kohima bench, where Minister Hill, Kohima, Nagaland, as the respondent number 7 to the instant proceedings. 6 is already there, land record.
One is the petition.
Okay. Respond number 6 to the accompanying with petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties by 7/6/2024. And the registry shall, on the basis of the same memo of parties and the instant order, make necessary correction to the accompanying writ petition and also update the same in the CIS. I can dispose writ petition. Mr. So-and-so, the learned counsel appearing on behalf of the newly impleaded respondent number 6, submits that he requires 2 weeks' time for filing their affidavit in opposition. You are filing affidavit. You are also going to file. You are the main person. You have cancelled it. The additional advocate general, the learned additional advocate general, Mr. I himself has also submitted that he would also, that the state would also like to file their affidavit in opposition. Taking into account the above, this the matter again on 28th of June 2024. In the meantime, the affidavits be filed by 26th of June 2024. Same order. Same order. So that I will come, will pass the same order. But your case is on 26, not on that, because that appeal is pending.
Which one thing, but there is an appeal order, not so. Let me say pursuant to the commissioner.
Understood. That may send it to the commissioner. You see, as per the Assam Land Revenue Regulation, it is the commissioner who can cancel. You see, Rule 26, it is not the deputy commissioner who can cancel. You want amend it, bring it. These are things which are necessary. How can you do it? Because the settlement rules applies here.
For motion, item number 46, Ling read item number 6.
Yes, madam. You have filed this I. What is this for? Commissioner and Secretary Nagaland, same. This is appearing. Why do you want? Release salary. This is an application filed by the petitioner as the applicant to implead the Commissioner and Secretary to the Government of Nagaland, Department of Health and Family Welfare, Nagaland, Kohima as the respondent number 4 to the accompanying petition. This court have duly taken note of the dispute involved in the instant proceedings wherein the petitioner has filed the instant petition being aggrieved by non-release of the salary. Taking into account that the Commissioner and Secretary to the Government of Nagaland, Department of Health and Family Welfare could be a necessary party to the instant proceedings, this court therefore impledes the Commissioner and Secretary to the Government of Nagaland, Department of Health and Family Welfare, Nagaland, as the respondent number 4 to the accompanying petition. The council appearing on behalf of the petitioner is directed to submit a fresh memo of parties before the registry of this court by 7/6/2024. The registry shall, on the basis of the instant order as well as the fresh memo of parties so filed, shall make necessary changes in the cause title of the accompanying petition and also update the same in the CIS. I stands allowed. Ms. So-and-so appearing on behalf of the respondents submits that a joint affidavit would be filed on behalf of all the submits that the affidavit is yet to be filed by the other respondents, taking into account the new respondent have been arrayed as a party. She would like to take. She would further seek 3 weeks time for filing the affidavit. Accordingly, list the matter on 1st of July 2024. The affidavit be filed by 28th of June 2024.
For admission, item number 1.
Worship, I get permission of the department motion.
Reply not filed?
No.
Oh, they are to file. You are already, you already have your arms. You've already filed your reply. Huh? Not necessary. Where is the reply? Oh, yes, yes. What is the matter about? 22/9/2004. When? 2000? 1819 also this happened. What happened? Where is the last order? 2017.
Page 49. Portion was will find page
Page?
5. July 2020.
2/7/2020.
Lord. But this order launched
So in terms with the what you call the leave granted by this court, you find the second. Who is appearing for the private respondents? They have not. Yes, madam. Why you have done this thing? Let us see what is your standing on. They say that you are in 16. Then others are what?
and that's the
However, the answering deponent humbly submits that out of the 15 juniors, 3 of them were directly appointed to the regular post. Okay. Now, madam, you produce the minutes of that meeting that you have considered these aspects which you are mentioning. I think that's the answer. And we expect in the meantime, I will reply denying. You don't deny to this, we will never. Next Tuesday will fix it. She's produced that. This is the minutes of that meeting that they have taken into consideration why you have not been given the passport of peace. And in the meantime, you deny to this that they have not done it. Affidavit not necessary. You produce the records. You file your short affidavit. The instant writ petition has been filed by the petitioner, being agreed by the actions of the respondents in not regularizing the services of the petitioner. Though the petitioner was senior to most of the private respondents who have already been regularized. The learned counsel, appearing on behalf of the petitioner, has drawn the attention of this court to clause number 4 of the office memorandum dated 22/9/2004, wherein the parameters for the purpose of regularization has been stated to be merit, seniority or merit. The learned counsel therefore submitted that when the seniority, that seniority shall only has to be therefore has to be taken on this. Therefore submits that the seniority has to take the forefront, and it is only when the seniority is the same, then the merit can be taken into consideration. On the other hand, the learned counsel, appearing on behalf of the respondent, drawing the attention of this court to paragraph number 4 and 5 of the affidavit in opposition, submitted that for the purpose of regularization, not only the seniority aspect is required to be taken into consideration, but also the aspect pertaining to the past service, past record, such as regular attendance, duty performance report from the concerned controlling officer oblique NE oblique apostrophe S, NE capital apostrophe S, oblique AME and JE apostrophe S, under whose supervision the employee is working, has also to be considered. It has been also admitted that out of the 15, also submitted that as regards the allegation which have been made that there were 15 junior persons who have been regularized out of the, it has also been submitted that as regards the allegation that 15 junior to the petitioner have been regularized is not true, in as much as the persons at serial number 6, 7, and 8 were directly appointed to the regular post. As regards 12 remaining, they were admittedly juniors, but their past records were better than that of the petitioner. So, taking into account the above, this court fixes the matter again on 11/6/2024. In the council appearing on behalf of the state shall produce the minutes of the meeting as regards the departmental regularization board, wherein the petitioner's case were also taken up for consideration along with the 12 other junior persons who were junior to the petitioner. Mr. Muajami, the learned counsel appearing on behalf of the petitioner, submits that he may also be given the permission to file a short reply to the affidavit. The petitioner would be at liberty to file their reply by serving an advance copy to the respondent by 10th of June 2024. Matter be shown as parted. Matter be shown as parted.
For admission, item number 2.
Yes, what is this?
Lordship, this is a dispute which began at the process of the village court. In the village court, it came up to the court of the district judge, the Nevoto, and Justice Judge Zinaboto, in terms of the provisions of the rules of 1937, ordered a de novo trial. But in ordering the de novo trial, a technical aspect now, the decision of the village council was not set aside. In ordering a de novo trial, the decision of the village council was not set aside. That is the only problem, Madam.
Village council was not challenged.
It was challenged, Madam. It was challenged.
So they have gone for ordering for de novo
De novo
trial.
trial. But in ordering the de novo trial, the decision of the village council was not set aside.
But isn't that the mandate that
Implied,
the
Madam.
court, if normally the village council's order should be kept, if it is possible as per the principles of equity, good conscience, or whatever may
Madam.
be. But otherwise, the deputy commissioner has the due power to go for a de novo,
Yes,
the
madam.
district magistrate or
Yes,
whoever has the due power to go for de novo trial.
Madam.
So what is wrong?
What about the decision of the village council, Madam?
Village council doesn't remain. It will go for a de
That is why,
novo.
my lord. That is why, my lord. But the stand taken by the other side, because I anticipated this problem, Lordship. And when I go back and file a fresh case for that matter, the ground will be taken that you have not challenged the decision of the village council has not been set aside.
But the village council decision cannot remain if it goes for a de novo trial,
Yes,
because the
ma'am.
deputy commissioner
Yes.
very well, either he has to do it. The
Yes, ma'am.
moment he thinks about the de novo trial, then the question of the earlier proceedings have gone for a
Yes,
six.
madam. And then, in addition to that, there is another problem, madam. Now, there is a disconnect between the judicial officers in the erstwhile 1937 rules and the present judicial officers under the rules of 2006. That matter is not pending before the division bench.
Before?
The division bench. So there was one judgment which says that from the customary courts, an appeal would lie to the judicial officers under the judicial service rules of 2006. Another judgment disagreed.
The matter, there are two single bench
Yes, ma'am.
judgments.
So that is not pending before the
And to a reference, where
Yes,
is
ma'am.
when is the matter listed?
before the division bench, Your Lordship. It was listed last week, I think. Last week it was listed.
This matter needs to be early
Yes,
disposed
my
of,
lord. It needs to be
because
disposed
this
of.
will otherwise clog everywhere.
Yes.
But anyways, the fact that you have only challenged that aspect of the matter, why
Yes,
should
madam.
we go into the other aspect today?
Where do I go then, ma'am? That is the problem.
Understood. They may go for a de novo trial. Now, there has been that in 1937 rules give it to you. They also, the Honorable shall have the same thing.
Yes.
But the only thing is that they have come up with that Civil Courts Act.
Yes. We
Which
don't
is
have that
not
yet.
that.
We don't
That
have
is the 37 rules of administration of justice. In fact, this is a 227 matter.
Yes, madam.
It's wrongly listed before this court as a writ petition. Yes, what do you have to say?
My lord, my first leg of objection is that the writ petition is not maintainable under 227.
Why?
My lord, as per the decision of the apex court, the nomenclature of writ petition cannot be used under file a petition under section article 227.
Why 227 not maintainable?
Just on the ground of nomenclature. On the ground of
Ah,
nomenclature.
That is one aspect of my lord. And the other aspect is that there's alternative remedy available to the
Where?
petitioner. My lord.
Where?
My lord, the village courts,
No,
Judgment, that is-
Mr. Counsel, these
My
are
lord.
not, nothing to challenge anything. He is only worried that what has to be an interpretation to be given when there is a de novo trial.
Yes.
This is his question out here. It is a question of law.
Yes.
Forget about other things. As to what is that, we give a clarification only that de novo trial, whenever he goes for a de novo trial, it means that the earlier decision has to be. Where is that provision section?
31, rule 31.
Rule 31. The amendment has not been given effect, no?
No, madam.
An appeal shall lie from the decision of the Muzada Gambura Dobashi to the tribal court, wherever constituted or otherwise. This is number 2. The deputy commissioner or the extent, a record shall be made to the matter in dispute, and if necessary, the court shall examine the particular if the court sees reasons to doubt the decision, it will try the case de novo or refer it to the Panchayat board. Now, where is the order of the Deputy Commissioner? What is the district judge doing? Why the district judge is here? Order of the district judge?
Yes, madam.
Why?
The district judge allowed the de novo trial.
According to the settlement order passed by the so-and-so is without jurisdiction and therefore set aside and quashed. However, the appellant says AI is given the approach vote by filing proper suit for declaration AI so-and-so. It has already been quashed. What do you mean?
My lord, here the order that was under challenge was DB's court order before the district judge. Not against the order of the village court. In this appeal, which was before the district judge, the appeal was against the order of the Dubashi court.
Okay.
That is the matter. And not the settlement order of the village court.
Seems to rule 31 about so-and-so. Who was the appellant?
Myself, my lord. I want that.
Okay, you are the
Yes.
appellant. And you say, and that order of the Dubashi court has, the order of the settlement order of the Dubashi court has been set aside.
My lord.
Then why are you here? Because you agreed
Yes, madam.
with
No.
the settlement.
The Washington court order has been set aside. But the village council court.
Can be?
In his favor.
Ah.
Washington court order is in my favor.
Within the village council's order, there is a doctrine of merger wouldn't apply.
It will not apply.
Then how does that remain?
And on these two counts, madam, the other count is the resolution.
What is your case? Let us see what is your case. Very difficult to understand that. And in the interim, the pending settlement order, stay the settlement dated so and so passed by Dubashi court. Wash the settlement dated 4/10/2000 passed by the village council. Now, did you challenge the village council's order?
Village council decision was in my, against that I filed an appeal
Where?
for a deputy commissioner. The deputy commissioner endorsed it to the Dubashi's court.
Appeal to the deputy commissioner and he referred to the Dubashi court.
Yes, madam.
How is it
That is
possible?
the process, madam.
Is it? Let's see how the deputy commissioner does it. From a village council, how does it go to deputy commissioner? An appeal lies only from a Dubashi to the deputy commissioner. That I know. The village council, where is it? The reference is made under 20 or the village authorities sitting under the village elders, so and so, they may not try suits and so and so. But there is a proceedings now by which a reference the hence court shall try and decide such civil only referred by the Iman to the extent to itself. Under what provision this was referred? 23.
Yes. I remember to the rule. Washington can try cases only stand not by the deputy.
Okay.
So when I filed it, to the Dubashi.
Hmm.
Dubashi's court was the Dubashi's court was the one in my favor, reversing the decision of the court. They filed an appeal. The commission took up now.
First is the village council's order is when?
4/10/11.
4/10/11. In your favor?
No, against me.
Okay, against petitioner. You file appeal to DC.
Yes, ma'am.
DC send it to the Dubashi.
Yes,
Dubashi pass an order on
6/2/12.
6.
212.
212 in favor of you,
The other side.
huh?
The other side.
Him. Again, against the petitioner, you file an appeal.
I find. No, my lord.
The
Yes.
village council's order is in your favor or
No,
against
no.
it?
Sorry, my lord.
Yeah, there.
Village council's decision is against me.
Yes. Then the Dubashi 6/2,
In my favor.
2012
In
in
my
your
favor.
favor for the petitioner. Then against the Dobashi appeal file
Like that.
and the district judge,
Order de novo trial.
that is the order dated
Order dated 8, 25, 4, 22.
25 for 2022.
In first appeal, 1 of 2016.
Where is the de novo trial given?
Will be there in the.
No,
report of the district judge.
let's see the order. It doesn't say so. Isn't this the order at page 69?
Yes, madam. Yes.
Accordingly, the settlement, this is 212. You are
212,
saying
yes,
6
212.
2 to 12.
2 to 12.
2 to 12.
Passed by.
Passed by Dobashi is without jurisdiction and therefore set aside. However, appellants are given the liberty to approach the competent area by filing suit. So you have to file a suit.
Yes, madam.
Where is the de novo trial? It's not a de novo trial. The de novo trial concept is only when he does not accept it. Okay, now I am going to go for a fresh trial.
Madam.
That is 31.
Madam.
Then, so under such circumstances, this order of the year has been 2-2 has been set aside.
Madam.
2-2 set aside. 2-2 set aside means coming 4/10/2011 again comes into force.
Pardon, madam?
4/10/2011 doesn't it come into force?
Madam, yes.
Then why you are challenging 4/10/2011 again? You are therefore to challenge this 4/10/11. What is the what did 4/10/11 say?
My lord, 1411.
That is in your favor, against you.
1411 is against me.
Accordingly, the matter was decided by the village authority after due consideration of all the available evidence and in consonance of the Sumi Iman and so dated so and so. However, against the word, the appeal against the Iraqi deputy commissioner, SDO endorsed the matter to mercy and decided the claim and reversed the judgment of so and so. And therefore, the appeal against the state settlement order dated so and so in the state appeal petition of the so and so was considered. Yes. As I said, the Dobashi court cannot be the appellate authority.
That's right. That's okay, my lord. I don't have any quarrel against that.
No, no,
It's
no.
already
Therefore,
decided.
it is on the question of jurisdiction. So wouldn't that the order of
No, my
410
lord.
come in?
No, my lord. If I may.
Yes.
Your lordship will see at page 64. At page 64 of the of my repetition.
64.
Yes.
Yes.
The second paragraph. This is an appeal under Rule 31. This is an appeal under Rule 31. Now, if your lordship will read that with paragraph 14, may I read paragraph 14 at page 69?
No, before that, come to paragraph number 5. Just first, the starting of page 66, the first line at page 66.
Page 66.
Yeah.
Appeal against the lordship.
And no, page 66. And thereafter, the appellant appeal against the said settlement order.
Yes.
So, of the Dobashi court before the deputy commissioner.
Yes.
Now, the deputy commissioner again endorsed the matter to the PA to the deputy commissioner.
Yes.
And was considered and decided by settlement order has happened. This was put to challenge before this court, and this court, the PA to the DC has no business of it. Then against that, now kindly see, accordingly, paragraph 6, accordingly, this appeal has been prepared by the present appellant with a prayer to set aside so and so. So this appeal is filed under 31.
Yes, ma'am.
Now the court says out here, then look here, these customary practice, all these things are different aspects of the matter. We need not go into, and this will require some evidence and all. But the most pertinent thing is that as to whether the Dobashi court at all could have been the appellate authority
No.
against the order of the village council.
I agree.
So under such circumstances, the order of the village council, the court said that no, nothing doing that. The Dobashi court did not have the jurisdiction, and as such, the order of 2012
Yes, ma'am.
was set aside.
Yes.
Now you are challenging the 410/2011 order, which came into existence in view of this by way of a writ petition.
No, my lord. If I may explain. If your lordship will kindly come to paragraph 14 again.
14.
Yes. At page 69. Accordingly, the settlement order dated 2/12 passed by the cautious court and the jurisdiction and therefore success cautious. However, the appellant as well as the respondent is hereby given the liberty to approach the court of limited jurisdiction by filing proper suit for declaration and determination of issues. Both sides, my lord.
Whoever is aggrieved,
Yes, both sides.
in fact, it should have been if you are aggrieved with the order of 410, then you are to it. But otherwise, the 410 order has already resigned.
No, your lordship, the point is this. The liberty given is both sides to file a proper civil suit. In a civil suit, a judicial order cannot be challenged. In a civil suit, can a judicial order be challenged, your lordship? The decision of the village council is a judicial order. It is a judicial order, your lordship.
So you say the court should have taken up, but it was only 2012.
All issues are open, my lord. As far as the appellate court is concerned, under Rule 31, all issues are open. And therefore, the power to order a general.
Don't you think that it would be a case that you need to again file on the 31? Now, in view of that order of 212,
Your
was
lordship,
endorsed to the Dobashi court.
my lord,
You filed an appeal on the 31.
My lord. my lord. So the point is this: when the liberty has been given to both sides to file a civil suit for the proper remedies, that order of the village council must be interfered with on the judicial side. It cannot be by way of a civil suit matter. So when the liberty to file a civil suit has been given as a necessary corollary, as a consequence, the judicial order ought to have gone. That is my point. And they have no challenges of this decision, Your Lordship. So the liberty has been given to both sides to file a civil suit. I'll file a civil suit. It's not a problem. But that judicial order still hangs over my head. As far as the village council being the decision of the village council being a judicial order, Your Lordship, there's a decision way back by Justice Sema is already there. under the rules. Decisions of the village councils are judicial decisions and they operate as res judicata.
Village courts. Village council is village court.
Yes, my lord.
So your submission is that in view of the setting aside of the order dated 2/2/2012, the order dated 4/10/2011 has come into existence.
Yes, my lord.
Now, that 4/10/2011, you cannot challenge by filing a suit.
Yes, my lord.
Or for that matter, the court
Ought to have taken that aspect into consideration in allowing me the liberty to file a suit.
but appeal was only against
As I was saying earlier, Lordship, in an appeal under the rules, all issues are open. Therefore, the authority to order appeal of the fact. The appeal was his. If I may, with all due respect, if we do not go too much on the technical side, can this order not be taken as an order to try de novo? Because it was an appeal under 31.
No, therefore I'm saying, that is what I'm saying. So this portion of the order, paragraph 14, will limit only to the extent that filing a suit be interfered with, thereby directing the district judge to take up the matter of 410 now, because the appeal is against that, the appeal, original appeal. But otherwise, I think the best option is for you to file, giving you the liberty to file and challenge the order of 410 before the district judge.
Otherwise, Your Lordship, this is a petition under 227. This is a petition under 227. And this honorable court does have the jurisdiction to set things right.
That is what I'm trying to set out.
Yes, my lord.
The
So,
only way, how do you do it?
Your
Because
Lordship,
you say
Your Lordship,
that the order of 410/2001 remains.
yes, my lord.
You say by way of a suit, that order cannot, the is an appellate forum, unless you say that it is only, a civil suit only would be permissible if it is a case of a court having no jurisdiction, passing an order. But kindly see this paragraph, which is very relevant. Kindly see paragraph 9, 8 and 9 of that order. I've heard the submissions made by the Learned Council of Puducherry. Upon hearing the Learned Council and
Yes, my lord.
all the material, this court of the considered view that it may not be in the interest of justice and appropriate for this appellate court
Yes, my lord.
to adjudicate on the contentious issue of Sumi Naga customary laws and practices relating to appointment of Gauhati chieftains.
Yes, my lord.
This court is of the opinion that determination of the customary laws and practices needs adducing of evidence
Yes, my lord.
and examination of witnesses by a court of competent jurisdiction. It is also the continued considered opinion of this court that such questions of facts for determination of customary practice and procedure have to be proved by the parties by leading proper evidence in support of their claims in an appropriate form.
Yes, my lord.
So under such circumstances,
My lord.
wasn't it necessary for the court,
Yes, my lord.
after setting aside the Gauhati court's order, to take it up when it was the jurisdiction?
Yes, my lord.
But the fact remains that the order you have whoever had challenged the district judge's order, in fact, the order, it was as if the same appellate authority exercising the same appellate authority order.
My lord.
The Gauhati court's appeal or the order could it have been decided by the the district judge or the deputy commissioner?
Yes, my lord.
How?
That by ordering a de novo trial under 31, by ordering a de novo trial.
So therefore, you see, this order of the 4/10/2011 was put to challenge.
My lord.
Once it is been put to challenge, the jurisdiction ought to have been of the deputy commissioner not to refer it to the Debasi.
My lord.
Debasi will only come into existence when there is a dispute. You request the ADC to decide,
Yes,
or
ma'am.
ADC to decide, then under 23
That
or
is right, ma'am.
23A,
I agree,
he will
ma'am.
send it to the Debasi.
Agreed, my lord.
Now here what has happened, the order of the Debasi, or order of the village council, the deputy commissioner could have done that.
My lord.
What he did, he exercised 23A and sent it to the Debasi.
My lord.
Or it is something like he had delegated the power to the Debasi to do it,
Yes, ma'am.
which he could not have done.
Yes, my lord. I agree, ma'am.
Now, once he has sent it, wouldn't that be the authority when he delegates the power to do it?
My lord.
Can that order be put to challenge under under 31? Which happened here.
Yes, my lord.
That order of delegation and then the order being passed by the Dobashi court is again being challenged under 31.
Yes, ma'am.
And accordingly, the 31 challenge.
In that case, my
said
lord.
that the Dobashi could
In
not
that case,
have,
my lord. In that case, the 31
without
appeal.
interfering.
The 31 appeal in the first instance is his appeal. In the first instance, the 31 appeal is his appeal. The application for,
2012.
yes, is his appeal. He appealed and it was endorsed to Bashi's.
No,
Yes,
your
my lord,
appeal.
yes. Yes, I'm getting mixed up here. I am getting mixed up there. My apologies.
So
Yes.
therefore, he the delegated exercise of power which has been made by the Dobashi court
Yes,
on the basis, because it was not sent for arbitration or whatever.
yes, ma'am.
It was sent for the purpose of a decision against an order which the court drafted. He could not have done. So the 31 does not permit sending it back. Let's see 31, what does it say?
No, this is, Your Lordship,
Kindly see 31. Or refer to the panchayat as above. Kindly see. A decision made by a member of the area shall examine the party that if necessary decision appears just as form and enforce it as its form. So they will put what the deputy commissioner requires to do is to put a stamp of authority.
there is another
And
provision.
confirm it.
There is another provision by which the commissioner or his assistant can perform actions.
So that is the 23A. And I knew that, I remember that.
Yes,
23A.
ma'am. Yes.
You see, the Dubasi henceforth shall try and decide civil cases only as may be referred to them by the deputy commissioner or whatsoever.
Yes, ma'am.
So this is another aspect where if there is a dispute, you approach the deputy commissioner, the deputy commissioner,
Yes, ma'am.
This is another. What we did in exercise of the power under 31, they exercise the power under 23
Yes, ma'am.
and ask the deputy Dubasi to do,
Yes.
which could not have been done.
Yes.
Therefore, the Dubasi was wrong in
Yes.
deciding this.
Yes.
To sit over the order passed by the village council. That is one aspect. So against that exercise, which otherwise it's like a delegated exercise.
Yes.
If I delegate, if you give a particular A officer out here that you have the jurisdiction, he delegates to B. It is the exercise of the power by A only.
Yes, ma'am.
So the appeal is against the Dubasi, which is the power of delegated power exercise of here. Again, 31 is being against this, which ought not to have been against the order, and all mistakes happen because instead of 31, the deputy commissioner exercised 53A.
Yes, ma'am.
So the only answer way out here to solve the dispute is directing the court. I can give you a usually appeal under 31 against 410. That's the only way out. And then the deputy commissioner may either, or the district judge may either interfere and confirm it or in overtime.
That is one way. That is one.
That's the only way.
If I may, madam,
Yes,
if I may, madam. By the passing of the order, as the direction is continuing in paragraph 15, all the developments prior to the decision of the new district have merged here, have merged into this one. And the Honorable District Judge has given the liberty to both sides to find a proper solution to adjudicate all issues between them. That is my case.
So, that,
So therefore,
no, Alice, therefore, the district judge decided on his own because the power he is exercising in the 31, which permits him to do that or refer to the
Yes.
that. So when he had the power, was it necessary for him to send it to everybody else? That go there. When he had the power to do it.
yes, madam. So ultimately, it was done by the district judge. That's what I'm saying.
So it was, but how can he do it? Because the only challenge for him is the order of 212, which he has challenged.
Yes, Lordship is correct to that aspect.
No, Your Lordship, what I'm saying is
Because by contention is that the learned district judge has not interfered with the order, settlement order of 4/10/2011. Since there was no appeal or cross appeal by the petitioner, the appeal was against the order of worship. My lord, the division bench of this honorable court has held that the worship court has no appellate authority. As far as no jurisdiction. So on that aspect,
In fact, in this case, as
Madam.
I was saying,
Madam.
the deputy commissioner ought to have exercised the powers of the 31.
yes,
What he did, he exercised the powers of the 23A. And there the problem arose.
Yes,
and
ma'am.
thereby
Yes.
delegated his power
Ma'am.
of 31 to the Dubashi. And therefore the Dubashi acted as an appellate authority, whereas Dubashi can never be an appellate authority.
Ma'am.
That's
Yes.
the problem, right?
Yes.
So he has to therefore challenge court and the
Yes.
district judge.
so. That's
Or
why.
you can file a suit. But filing of a suit, the problem arises there is an order of the village council.
Correct, Lordship. Correct. Lordship.
So that is why I'm on that point. If a sentence should have been allowed, the order of the village council should have been different. That's what I'm saying, madam. Because under Rule 31, all issues are open.
So that means you want to on an order being passed by so and so, where the order of the Govasi court has been interfered with, where the court has not taken into consideration 14 whether it is right or wrong. You want this court to say
No, my lord.
that 14 is wiped out.
No, 14 has been taken into consideration. Only discussions which your worship was referring to, paragraph 89. So the district judge has come to a conclusion that such customary practices
But
require evidence.
even the district judge is exercising 31, the district judge to do it.
Actually, yes. That is what I'm saying.
Therefore, I'm saying, this is the only way of giving you ideas.
On that aspect,
This
on
court,
that,
however, because there is no challenge by you.
on that aspect, my lord, I agree. Now, the difficulty is now to disconnect between the customary courts and the judicial courts. Where do I go?
Because
The decision which I was talking about earlier, your worship, one decision says on the customary courts, judicial courts are the judicial functions of the business. Other judgment says no.
what that judgment say?
Where there is no provision, or there is no provision for the appeal to lie to the regular civil courts from decisions rendered under the rules.
So you file an appeal and before the deputy commissioner, let the deputy commissioner delegate it to or put it before the district judge. Why do we have
Your
to
worship, yes, we have been doing so many exercises to have separation of rules. Issue from legislation. And this aspect is one aspect. I would be much more comfortable before a regular civil court than going before the district court.
let's see how 84 amendment has not yet been brought in
For the customary courts? No.
No, just for example, the 224, has it been brought in? Private court has not brought,
No.
so it will lie with the
Yes, no.
so it is for a deputy commissioner, they will decide what to do. You value a fee.
In that case, Josh, I have already filed the plea.
No,
Where you have filed the plea? Wrongly
file an
endorsed.
appeal there. But that appeal was referred to the Dumashi court.
Yes, ma'am.
It has been wrongly done. There the problem arises. Therefore, I'm saying the problem arises in view of the exercise of the power of the 23A. There's no limitation.
There is.
30 days. 30 days. Without this phase. So, this period of filing that key till date be excluded.
That case will be 2 years.
That period has to be filing the first before you file the key against the orders it express.
That appeal was filed within time.
That was filed. So, you file it, I think you do another 20 days. Or instead of that, you do 30 days for filing a key.
I can do that. Only consideration I will pay for it. I want to file before the regular season.
How do you challenge it? Order of
That-
the
That process is not to be.
no, you can very well go to the DC or wherever it is, tell him, then look here, this is the finding of fact which has been designed, this is that this. You may decide after go for this in the
Commissioner.
for the deputy commissioner. You have to file the appeal before the deputy commissioner.
Yes, and it will be taken up by the deputy commissioner.
Huh?
It will be taken up by the deputy commissioner. No one else. Not the regular civil court. Cannot prefer.
So you have it to refer to the file the appeal before the deputy commissioner. Deputy commissioner,
So in that case, the decision of the district judge, which allows civil suit,
because this will, this will not, not, I would not only paragraph 15 that should. I would put them, but directly finding of the civil suit, because the civil suit is filed by either of the party. It will amount to what will happen to the order of 210 without that being touching. Or I can do one thing, I can remand this matter back to the tribunal, but do I exercise the power of the yes, I can hear before the decide.
this one, the
That
margin
is
back,
the best way.
that is the best.
Take into consideration, but it is his appeal.
That's wonderful.
So, how does it make sense that if I demand it back to him?
Because
Because he cannot decide,
he cannot decide this.
because in that order of 410 is not before him.
Exactly, but
The problem arises
Yes,
there, na?
exactly.
410 is not before him.
210 is before him, Your Lordship.
No, 212 is there, 212 is with the jurisdiction he has, holds it rightly. So only remain is 410. 410 is not before him. How do he
Yes.
exercise the power? Unless there's an impugn, there's an appeal memo challenging it, how do you do it?
Of course, Your Lordship. I understand. But what should I also consider? The without jurisdiction part is one aspect. But once the matter is placed before we limit the Deputy Commissioner. All issues are open.
He can't do anything. If the order of 410 was before him,
Yes, sir.
he could have very well said that, okay, let us go for Dino.
Yes, sir.
He could not have done for 212.
Very well done. Let me.
We only interfered at that because in view of that order, the consequences is the order of 410 comes into the picture. And there was already an appeal filed. But however, all these discourses have happened.
Yes, sir. One month time for today.
Yeah, we could see. This is an application under Article 2 to 7 of the Constitution, challenging the order dated 25/4/2022. Passed by the learned court of the district judge, Junihibut, Nagaland, whereby the appeal filed by the respondent hearing was allowed, thereby setting aside the settlement order dated 2012 passed by the Dobashi Court, Akulitu, under Jugi Koto district, on the ground that it lacked jurisdiction. The issue involved in the instant proceedings, however, due to the remaining portion of the order passed on in view of the further directions so given by the learned district judge, thereby granting liberty to both the petitioner as well as the respondent to approach the court of competent jurisdiction by filing proper suit for declaration and determination of issues relating to claim for appointment of geography, bracket GB of the chieftainship, bracket 2, at Supini village as per Suni Naga customary law and practice, if so advised. The issue involved, in view of the said directions, is what happens to the order dated 4/10/2011, which was passed by the Sutumi Village Authority on 4/10/2011, in as much as the civil courts would not have the jurisdiction to interfere with the said order in view of the rules of administration of justice and police in Nagaland 1937. To appreciate and understand the issue, this court finds it relevant to trace out the history of the instant litigation and leading to the filing of the instant proceedings in front. A dispute arose between the petitioner and the respondent as regards appointment. What is the dispute? As regards the appointment.
No, my lord.
As regards what?
Just chieftainship. The dispute was regarding chieftainship of the village.
Chieftainship is a as regards the appointment to a chieftainship or who is going to be appointed as what? What is this?
Because your lordship in the Seva custom, it is essential to chieftainship.
Huh?
Essential to chieftainship. Essential to chieftainship. Essential to chieftainship.
Or that is essential.
Essential.
The dispute arose as a dispute arose between the petitioner and the respondent, who would accede to the Ranguraship of the chiefmanship of the Sutumi village as per the Sutumi Naga Custodial law. The respondent approached the village council court of Sutumi village on 12/9/2011, seeking for declaration and restoration of his right to Ranguraship of Lokodomi group of Sutumi village. The Sutumi village authority decided the same dispute by passing an order on 4/10/2011. The same order of the Sutumi village authority went against the petitioner hearing. The petitioner, being agreed, appealed, prepared an appeal before the deputy commissioner, June B. Bhutto, in terms with section Rule 30 of the Rules for Administration of Justice and Police in Nagaland, 1937, for short, the Rules of 1937. The Deputy Commissioner Junior endorsed the appeal for disposal to the SDO Civil Apuluki. The problem arose in view of the further steps being taken by the SDO Civil Apuluki, inasmuch as the state official, instead of exercising the powers under Rule 31 of the Rules of 1937, exercised the power under Rule 23A of the same rules, and thereby referred the matter to the Dobashi court, to the Dobashi court, Apuluku, for a decision. This resulted in an order being passed by the Dobashi court on 2/12/2012. This order of the Dobashi court dated 2/12/2012.
11,
2/2012, not
11,
2012.
11.
No, no, 3/2012. No, no, page 66. These are 2/2. Then you have nothing. All are 2/2012. Which I think you have translated. How can it be to the 2nd of February? Because the order which was passed by the Supreme Village is quoted in that. 410.
41011.
So an appeal will be after that.
Yes, Your Honor.
So it should be 212.
Yes, Your Honor. Should be, but in the Justice Court order, it says 211.
This order of the Dubashi court. But again, put to appeal. The same order of 2012 of the Dubashi court went against the respondent hearing. The respondent hearing filed an appeal again before the Deputy Commissioner, Zunebe, in terms of section rule 31 of the rules of 1937. The same appeal was endorsed by the Deputy Commissioner, by the concerned Deputy Commissioner, to the PA, to the Deputy Commissioner. And on the basis thereof, an order was passed, settlement order was passed on 7/10/2013. This order of 7/10/2013 was put to challenge before this court in WPC number 210 bracket K of 2014. By the petitioner hearing, this court, by an order dated 13/5/2016, set aside the said settlement order dated 7/10/2013. On the ground that the PA to the Deputy Commissioner could not have passed the said order dated 7/10/2013. However, in doing so, the respondent herein, who had filed the appeal earlier against the order dated 2/12/2012, was granted the liberty to prepare an appeal for setting aside and quashing the settlement order dated 2/2012 passed by the Dobashi Court appeal to Unagato district. It is under such circumstances an appeal was prepared by the respondent hearing. Where did you find the appeal? Directly.
Malo.
Did you find directly to the
Yes, yes, directly to the
District
district judge, district judge.
How?
Malo, under rule 31 of the.
Has there been any amendment? The rule 31 the district judge can be.
That is,
That's the issue. Just
I find an appeal before the court of the district judge, Unagato, Nagaland, which was registered and numbered as first appeal number 1 of 2016. The learned district judge, Unagato, Nagaland, hereinafter referred to as the learned court below, interfered with the order of 2/2012 passed by the Dobashi Court on the ground that the Gauhati court could not have set on appeal against the order of the village authority, and accordingly set aside the same. It is very interesting to take note of. Set aside the same by the order dated by the judgment dated 25/4/2022, which has been impugned in the instance. In doing so, the learned court below have also taken into account that to adjudicate contentious issues of Sunni Naga customary laws and practices relating to appointment of Dangura of the chieftainship, there would be a requirement for determination of the customary laws and practice on the basis of evidence adduced and examination of witnesses by the court of competent jurisdiction. It was also observed that such questions of facts for determination of the customary practice and procedure has been proved by the parties by leaving proper evidence in support of their claims in an appropriate judicial court. On the basis of those observations, the learned court below granted liberty to both the petitioner as well as the respondent to approach the court of competent jurisdiction by filing proper suit for declaration and determination of the issues relating to the claim for appointment of guardianship, bracket, GB of the shipmanship, and supervision as per the Sunni Naga customary laws and practices which were advised. The question, however, arises that with the setting aside of the order dated 2/12/2012 passed by the Dobashi Court, the order dated 4/10/2011 passed by the Sutumi Village Authority comes into existence. Now, therefore, the issue which begs consideration before this court is as to whether the petitioner's hearing would be able to challenge the said order dated 4/10/2011 passed by the Sutumi Village Authority by way of a civil suit. That too when a statutory appeal is provided under Rule 31 of the Rules of 1937. Or for that matter, with, without the order dated 4/10, or for that matter, with the currency of the order dated 4/10/2011 subsisting, can the petitioner herein file to be successful in filing a suit I've heard the learned counsels appearing on behalf of the petitioners and have also taken due note of their respective submissions. This court has duly taken from the material, from the facts narrated herein above. It would be seen that the appeal, being first appeal number 1 of the 2016, was filed by the respondent herein before the learned court below, pursuant to the liberty so granted by this court in its judgment and order dated 13/5/2016 in WPC number 210K of 2014. The challenge in the said appeal was only in respect to the order dated 2/2/2012. The order passed by the Sutimi Village Council dated 4/10/2001, 11, was, however, not an issue before the learned first appellate court, before the learned court below. And in that view of the matter, the learned court below did not take into consideration the existence of the order dated 4/10/2001, 11, in passing the directions, in granting the liberty to both the parties to approach the competent civil court, competent court of jurisdiction, by filing proper suit for declaration and determination of the issues. This court makes it very clear that the findings as regards the order dated 2/2012 by the Dobashi court to the effect that the said court had no jurisdiction has been rightly passed. And as such, there is no and as such, the question of interference with that portion of the order does not arise. And in fact, the petitioners herein have also not assailed that aspect of the matter. However, with the coming into existence of the order dated 4/10/2011, passed by the Sutimi Village Council, a village court, pursuant to the setting aside of the order of the Dobashi court dated 2/2012, has to be challenged in the opinion of this court. In fact, in the opinion of this court, when the challenge was actually made on 4/10/2001, challenge was made to the order dated 4/10/2011 by the petitioner before the learned district judge, before the learned deputy commissioner. The deputy commissioner ought to have exercised the powers under Rule 31. The deputy commissioner or its delegate could have exercised the powers under Rule 31, or to have exercised the powers under Rule 31 of the rules of 37. But the mistake happened when the SDO, that particular bill had Thereupon, exercised the power under Rule 23A, which was not at all, which was totally unwarranted. Under such circumstances, this court is of the opinion that the portion of the impugned order, impugned judgment and order, that is, inverted comma, however, the appellant as well as the respondent is hereby given liberty to approach the court of competent jurisdiction by filing proper suit for declaration and determination of issues relating to claim for appointment of Gauhati bracket GB oblique chieftainship bracket close as Sutimi village as per Sumi Naga customary laws and practices, comma, if so advised, comma, close, stands interfered with thereby granting liberty to the petitioner herein to prefer an appeal against the order dated 4/10/2011 passed by the Sutimi village in terms with Rule 31 of the rules of 1937. This court further grants 30 days from the date of the instant judgment to the petitioner to prefer the said appeal. This court makes it clear before, accordingly, the instant petition stands disposed in terms of what have been stated above, then down below. Before parting with the record, this court makes it clear that this court have not decided on the question as to whether an appeal lies directly to the deputy commissioner or to the district judge in view of the pendency of a reference before the division bench. First, taking into account the above, this court directs, grants the liberty to the appellant, the petitioner, to file the appeal before the deputy commissioner in terms with Rule 31, and it shall be within the jurisdiction of the deputy commissioner to refer the matter to the district judge of the concerned district for decision. Solve it.
That will serve the purpose where it was like. A little circuitous route, but then back to the same position.
For admission, item number 3.
Both of you give your names. Put it out there.
Worship, in the item 3, I filed a reply to the affidavit of the private respondent in respect of the official respondents
When did you file?
few weeks ago.
It shows that no reply has been filed.
In respect of the official respondents. 2 weeks then. 2 weeks.
What is the matter about?
It's about seniority. It's about seniority.
The counsel appearing on behalf of the petitioner seeks a further 2 weeks' time for filing the reply to the affidavit in opposition filed by the
State respondents.
respondent.
1 and 2.
Numbers 1 and 2. Taking into account the said submission, the matter stands adjourned to be listed again on 2nd of July 2024. In the meantime, the reply be filed by
For admission,
Mr.
item
Counsel, don't you think that with this taking into account the volume in which
Yes, madam.
heard the learned counsels appearing on behalf of the petitioner as well as the respondents. Taking into account the matter and there being issues involved which requires a determination, this law issues rule as the respondents are duly represented. There is no requirement and have already filed their pleadings. There is no requirement of filing of issuance of fresh notice. List the matter for hearing on 2nd of July 2024. In the meantime, the petitioner, if so advised, to be at liberty to file their reply to the affidavit filed by the respondent on 28th of June 2024 by serving advance notice. Maintain notice after it shall continue till the disposal of the petition.
For admission, item number 4.
Minimum scale of pay. It's a case of minimum scale of pay. You want the minimum scale of pay. You fix it on 21st. 21/6, you file your reply. But there other matters are there. They have formed the committee on 16th 2024. And I've asked them to file their affidavit in one matter. Where as regards the update which they have taken as regards this. Depending on that, what comes up, but this court can't pass on to the refer. It has to grant you more than that. When the matter is now under consideration by the state. Huh? No, in the meantime, she filed her reply. We fix it on 21st. She's asking for the minimum scale of pay, which is otherwise given to the regular employees. Isn't it? And you have not received your salary from? Why you have not paid the salary, madam? You filed your affidavit. Why did you say?
Because of the petition. Verification is undergoing.
Hmm?
Verification is undergoing regarding the records.
You're working 3 years. How do you take care of that? How long are you going to take into consideration the verification? Let's see, where is it? What is your reply to the payment of salary? You can't have it for so long.
So there are some cases where due to the registration in the fields,
You file your on 13th of May, and she has not got he or she has not got the salary from 2020 and 2021. Then how are they going to survive? You are taking their services also. The instant petition has been filed by the petitioner, being agreed by the non-payment of salary to the petitioner number 1 since July 2021. And as regards the petitioner number 2, since March 2020. In addition to that, the petitioners have also claimed that the petitioners are entitled to the minimum scale of pay in terms with the judgment of the Supreme Court in the case of State of Punjab versus Union of India, State of Punjab versus Jagjit Singh, reported in 2017. The respondents have filed an affidavit on 13/5/2024, wherein it has been mentioned that on account of certain discrepancies which were found in the petitioner's service records, certain verifications have been conducted. And it is on account of the said verification that pending salaries have not been released. It is, however, not understandable as to why, as to how the respondent authorities can keep the salary spending since 2020 and 2021, 2021 and 2020 in the case of the petitioner, number 1 and 2 respectively. That is for a period of 3 years and 4 years, and there is a question of on the ground that there is some verification conducted. It is believed and understood that the state authorities, that the state is required to decide the entitlement of the petitioner at the earliest. Under such circumstances, this court therefore directs the state authorities to conclude the verification as regards the salaries of the petitioner by giving them time till 28th of June 2024.
Verification is with regard to PIMS court level.
Huh?
So PIMS, now the salary is e-pay system. So when the PIM, certain PIMS registration. So if the, for example, if the name of the article is not telling,
So does it take 4 years?
it takes time.
4 years.
So you watch, I need
Come
the
up with this,
instructions.
you come up with it. 28th of June 2024, and as regards the next, and thereupon file an affidavit in that regard. As regards file an affidavit stating as regards what verification have been done and and also file an affidavit as regards compliance. This court, in respect to the other issue, this court taking into account that there is already a committee set up by the notification dated 16th of 2024 to file an affidavit intimating apprising this court as regards the decisions so taken in by the state committee, more particularly as regards the judgment of the Supreme Court in the case of Jagjit Singh Supla, which is the matter on 3rd of July, 4th of July 2024. In the meantime, you want to file reply? Right. In the meantime, the petitioners will be liberty to file their reply. The affidavit file. There is nothing out there. What is there to file in reply? In the meantime, the petitioner would be at liberty to file a reply, if any, on or before the next date.
For admission, item number 5.
Lordship, this is also a similar matter regarding non-release of salary from 2001. The Lordship will say it like unless and until the service reports are clear, it cannot get registered. And once it cannot be registered in the PINs, your Lordship, salary cannot be dispersed.
Huh?
The Lordship, the regulation is that, the PINs regulation is that unless until the service report is clear, it cannot be generated in the PINs. And if it cannot be generated, the service reports, because PINs is relates to
Madam, does it take 3 years?
no, your Lordship become operation.
Then why have
2000.
you not paid from January 2021?
That's why your Lordship is going in bulk, and recently.
Whatever may be,
Yes,
whatever may be,
yes.
can a person survive without salary?
No, your Lordship, the government is taking active.
What active?
Your Lordship,
How can
because
it be active?
the-
We taken more than 3 years.
it seems that district under Zimbabwe has already been cleared and sent.
Do you like your fees being expanded out
No,
there on the
no.
basis of your name not being properly put up?
No,
out
no,
there
your
for 3
Lordship,
years?
that is not the condition, your Lordship. No, that is
Same
not-
area. Your verification. Right?
Status
When
report.
the verification is complete.
Your Lordship, but
This is an application file. Petition has been filed. That petitioner being agreed by the non-release of the salary since January 2021. The council appearing on behalf of the petitioner submits that the petitioner is in dire straits on account of the non-release of the salary. Full stop. On the other hand, Ms.
Livika, your Lordship.
The learned counsel appearing on behalf of the state respondent submits that on account of certain verifications being conducted, the salary of the petitioner have been withheld. Full stop. In the opinion of this court, in the opinion of this court, the verifications so conducted cannot be conducted in such a manner thereby affecting the petitioner's right to life and liberty, right to life and livelihood, in as much as the salary is the means by which the petitioner can have a decent livelihood. So considering the above, this court directs the state respondents to complete the verification as regards the petitioner by 28th
Your
of
Lordship.
June 2024
Your Lordship, may I,
and file an affidavit by 4th of July 2024.
your Lordship, to file the status report in respect to the petitioner.
That is
Your
the
Lordship.
word. I have
Yes,
not the complete your verification as regards the petitioner
Yes, your Lordship.
and then file. I'm not
Yes.
asking you to release. In the earlier case also, I have not asked you to
Okay.
release. I've asked you to complete the
Your-
verification. Whatever may be, whether the petitioner is entitled or not, that
Oh,
you
your
do
Lordship.
it. Because it can't be like this. This is the
Much
matter
ob-
again on foot.
Yes.
For admission, item number 7.
Because at a later point of time, this accumulation, the state would not be in a position to pay anybody. Then you will say, let us pay in installments. Where will these people go? Yes, no, none appears. For either the petitioner or the respondent,
For a respondent.
you are there. What is the matter, Mr. Yangavati?
Voluntary retirement. Yes, sort of voluntary retirement, and otherwise after that he has stated that he has.
Where is he gone? Yesterday, he
court
was
number-
very much present throughout the day.
I think
So
he is
he
in
must
court
be
number
there
3.
in the parter.
In the morning, he has told me that he'll be filing his affidavit in reply.
Is the petitioner asking why the respondent should not. Why he is not entitled to invalid pension?
Lordship, while undergoing treatment, recruitment process training. So
Yes.
he was not enrolled also as a,
Hmm?
he was only undergoing treatment, training, Lordship. And during the treatment, he got injured.
Chalo. A perusal of the pleadings reveals that there are serious allegations being made or by the state respondent, by the union, by the respondents, stating inter alia that the petitioner is not entitled to the relief as has been sought for, more so on the ground of delay.
Oh.
However, in the opinion of this court, the petitioner is required to file a reply to the same. Accordingly, this court fixes the matter again on 2nd of July 2024. In the meantime, the petitioner is given an opportunity to file a reply on or before 28th of June 2024. Failure to do so, the court shall take up the instant matter on the basis of the pleadings available on the court.
For admission, item number 8.
Your Lordship, this matter released a minimum scale of pay. So if this matter can come up on the same day, Your Lordship, as fixed by this court.
We fix it on 21st.
Yes, Your Lordship.
The petitioner herein has filed the instant writ petition being aggrieved by the inaction on the part of the respondent authorities in not granting the petitioner the minimum scale of pay to which he's grateful.
Yes, Your Lordship.
A grateful employee, regular employee is entitled to. It is the case of the petitioner, but the petitioner's case is squarely covered by the judgment of the Supreme Court in the case of Jagjit, State of Punjab versus Jagjit Singh and others, reported in 2017, 1 SCC 148. Yeah, agote asil na 148. 148. On the other hand, Mrs. Livika, the learned counsel state respondent, submits that the government of Nagaland, in view of the state judgment, as well as other aspects of the matter, have constituted a committee by the notification dated 16 to 2024. However, on account of the model code of conduct operating, no decisions could be taken till date.
Yes.
List the matter again on 21st of June 2024. On which date the State Council shall apprise as to what is the status of the committee, status of the shall apprise this court as to whether any recommendations have been made by the state committees who constitute it.
From the supplementary cost list, for admission, item number 47.
You are there in the earlier matter.
Item number 8. Item number 8.
You are
Item number 8.
8. It is over. Yes.
In this case, if I may be allowed 2 weeks, I'll define it by also. I have certain information.
I fixed it yesterday.
Lodging, yes, lodging.
Today, why?
Finally, after the lodging.
What is that matter about?
Lodging.
Regularization,
Yes, lodging,
NPD.
these also for regularization. File an application and, yeah, significantly can.
Yes, madam. Yesterday we caught hold of this.
Yes, Your Lordship.
There was another council. You were there?
No, Lord.
Ah. There's another council. He said, okay, give me time till tomorrow. I will do the matter. Didn't there? Were you entitled to as per either of the schemes?
Lordship, as for 2015, no, Lordship. I did not come under the purview of.
Then how do you come in?
Lordship, the state has filed a affidavit stating that I'm chair number 4, Lordship, of the senior list as far as this carpenter is concerned, Lordship. I've sought some information regarding the vacancies as well as the
Now, how
regularization,
can
Lordship.
you having retired, how can you be regularized?
No, I'm in service, Lordship. I've completed 25 years this year, Lordship. I'm still in service, Lordship.
42 years. At whatever age did you work? You have another 5 years, no? 25 years. As for the Nagaland, it's 30 years, no?
35 length of service and 60 years, whichever is earlier, Lordship. 60 years of age or 35 length of service.
You got your service when you were 17. Huh? Illegal appointment. How can a minor be appointed? Yes, possible.
Lordship, I have to check the record, but apparently, Lordship is completed only 25 length of service, Lordship.
Huh?
He has completed only 25 years of service.
And you are in the scale of pay,
Yes, Lordship.
but you will complete another 5 years.
Yes, 5 years.
Then,
But 2004 is still in operation, Lordship. This is another office memorandum, 2004, 22/9/2004, Lordship.
then how do you get there? In view of clause 1 of the 15 amendment, office memorandum, which duly takes care of work charge, casual labor, everything, and you are in the scale of pay. How do you take care of that?
Lordship, but there's still the 2004, where it says that
So they will pick and
employees,
choose.
work-station employees can be considered.
Understood, but they pick and choose. They look here for Mr. Muajami, we put it at 2004, but for others, we have it for 2015.
No, therefore, Lordship, was the effective order.
But unless you challenge, because 2015 categorically says about all work charge also. You're a work charge.
Yes, Lordship.
You are in the
But
scale
more
of
like
pay.
operation, Lordship.
But if you are now being given, 2015 becomes useless.
2015 is only for those employees who complete 30 years of service.
No.
But 15, Lordship.
No, see clause 2.
Clause
Roman
is-
2.
Clause 1.
No, clause
Specific, Lordship.
1, Roman 2.
2015 or 2004?
Yes.
Lordship?
Clause 1, Roman 2. Page 19.
Yes, Lordship.
Then you will complete it. Whenever you complete, you will get it.
Yes, like he'll have to wait for his turn, Your Lordship.
You
His
don't
turn will
complete it
automatically
today.
come, Your
But
Lordship.
this is 2015, Lordship.
Yes.
Specifically saying that I have to complete 30 years of service, Lordship. But 2004 is still on operation, Lordship. And that applies to those employees who have not completed 30 years of service, Lordship.
But we have not challenged 2015. 15 still remains.
Both are in operation, Lordship. There is a
No,
specific
therefore,
instruction, Lordship.
there is one judgment where that I've stated that when there is the year between the 2015 has to prevail. Kindly see the reading of clause page 18. On due consideration of the report of work charge and casual commission and in compliance with the judgment and order of the Honorable High Court, the Governor of Nagaland is pleased to introduce the following scheme for regularization and absorption of the work charge, casual employees.
Subsequently, there is a instruction issued by the. There are for the fact that since it's still an that 2004 is basically for this.
So we're saying that it's outside the zone of consideration. At the time of filing the writ, the dean was 2 years. So he has to wait for another some more years to. Even when your lordship, even if we say that 2004 is outside the zone of consideration, because it's not the same. Under 2004, simulating is it's not the same. Suppose even then it is not. So you should
22/9/2024, on 27 May 2024.
And to take instructions.
Provisional pension. that the case?
from the supplementary course list, item number 50. Order.
His lordship, the only instruction that I got is that, lordship, initially, like, there was no service group governing them. So they were appointed as an ad hoc, as an SO, grade one lordship, and subsequently regularized, subsequently, like, promoted to SO grade two. Yes, your lordship. Yes, your lordship. Yes.
Once they are regularized, you go ahead.
Yes.
You have to do the mechanical being or civil engineering. But for getting a promotion, one needs to have a diploma.
Yes.
And if somebody has 7 years, works on the pedestal diploma, it can be very well promoted. Yes. So we interfere only to the effect that the petitioner hearing having this is entitled to promotion. That's all.
Lordship, if His lordship can kindly reflect my submission on it, lordship. Reflect my submission, but my paragraph 5 of the affidavit of position, that may be reflected to you.
That's all. Can you come to page 75? This is the one which you are concerned. What's the name of the petition?
Certified note 3, certificate course and others.
442 to 502 certificate course and others shall not be eligible for further promotion to the higher.
Yes,
That is the one. No?
that is it.
You have a diploma.
And both of us have diplomas in mechanical.
And this is for the seniority list for
NPWD.
all
Yes, sir.
mechanical everything.
No, this is for the NPWD civil.
Where is it?
The department itself, Your Lordship, NPWD. Though it is for the entire different branches, including mechanical and housing.
No,
This-
does the NPWD doesn't have the civil engineering department?
It does have.
Then
It does have the civil wing. So we were appointed in the civil wing under the NPWD. And this seniority list is of the civil
no,
wing.
but this seniority list does not say anything about which department.
Your Lordship will see in the seniority list the remarks against each of the
No,
persons.
understood. Can you
Yes.
come to annexure M?
Annexure
M.
M. Yes, madam. Seniority list of junior engineers under NPWD. As on March 2018, senior list of junior engineers, degree, diploma, and certificate holder under NPWD. It doesn't mention anything about civil as such.
Then
But the list of persons who are mentioned here, all are diploma in civil engineering, except for the both of us,
you are mechanical.
mechanical.
So they regularize you into the mechanical wing,
Into the civil wing, into the civil wing.
civil. wing.
Yes, ma'am.
But this does not say it to be civil.
Yes, it doesn't say.
But it is a seniority list of all the NPD
Under NPWD, Your Lordship, I have stated in my
for the
paragraph.
works and housing department established.
Yes, madam.
Under NPWD, there will be consisting of PWT R&D, PWT housing, PWT national highways, PWT planning and design.
Now, therefore, these seniority layers, and you see this at page 61. This seniority is the seniority list of all NPW
NPWT.
because
Except for
you
me.
see it is being forwarded.
Yes, madam.
The copy is forwarded to all the wings.
Yes, madam.
RNB, H, NH, PB.
Police engineering project.
Whatever. So these are the
But
three.
not mechanical.
But this excluding.
There's no mechanical wing.
There is a mechanical wing. There is a mechanical
We have, Your Lordship, but this maintain a separate seniority list. That is actually the question.
We have a separate wing.
Yeah, separate seniority list.
Now,
have
if
enclosed
a
that in my
person
activity.
who has a diploma in mechanical wing,
Yes, Your Lordship.
he is not in, he is appointed out there in the civil engineering wing. Is he not entitled to promotion?
He will be entitled, Your Lordship,
Then-
in his own stream, Your Lordship, in his own discipline, Your Lordship.
No, no. Show me in the rules which stipulates that he is not entitled to promotion. He has a diploma in mechanics in a civil engineering.
There's no such rule.
Then it is wrong. We interfere with that. The jurisdiction under Article 2 to 6 of the Constitution have been invoked by the two petitioners challenging the office memorandum, the memorandum dated 26/3/2018, whereby the petitioners who are at serial numbers, what are the serial numbers?
P1 is at 285 and P2 is at 305.
Serial number
285.
285 or 470? No, no.
471. 471 and 470.
You are at serial number 471
Yes, ma'am.
and
And 472.
First submission.
at serial number 471 and 472 have been held to be not eligible for
Yes.
further promotion to the higher grade. I've heard Mr. A. Jimomi, the learned counsel, appearing on behalf of the petitioner, and Ms. Lavika appearing on behalf of the state respondents. The petitioners, number one, was initially appointed as a, what is SO?
Sectional officer. Sectional officer.
Section. Was initially appointed as a sectional officer, grade 1. On the basis of an office order dated 15/6/1998. The said appointment was made on contract basis. Subsequently, no, full stop. The said engagement of the petitioner, number one, was extended from time to time. Subsequently, by an order dated 14/12/2006, the services of the petitioner number one was regularized with effect from 26/10/2006. Next paragraph. The petitioner number two was initially appointed on the basis of an office order dated 9/6/2003 and was appointed as sectional officer grade 2 on provisional basis. In the year 2007, by an order dated 14/12/2007, the petitioner number two was offered officiating promotion to sectional officer grade 1. Subsequent thereto, on 15/6/2009, The services of the petitioner number 2 was also regularized. At this stage, it is very pertinent to mention where is your qualification?
Your Lordship,
Where is your qualification?
the certificates, Your Lordship, I have not enclosed that, but I've said that we are both diplomas in mechanical engineering.
Isn't that the most important document you have not enclosed?
It is mentioned in the seniority list also, Your Lordship.
Where?
471, page,
Page 36?
page, page 74,
Where? Page 30?
page 74, Your Lordship.
At this stage, it is relevant to mention where?
In the column number 1, 2, 3, 4, diploma in mechanical engineering, 471, 472,
Page 30?
page 74.
34.
74, 74.
74.
Serial number 471, 472 again, diploma in mechanical engineering. The fourth column.
It is relevant to take note of at this stage that both the petitioners are diploma holders in mechanical engineering, as would appear in the memorandum dated 26/3/2018 itself. On 24/1/2012, a tentative seniority list of junior engineers serving in the Department of Works and Housing was circulated. In the said seniority list, the names of the petitioners were at serial number 285 and 305. Sometime in the year 2016, the petitioners came to learn that their names would be removed from the seniority list. Accordingly, the petitioners, along with two others, submitted a representation on 21/3/2016 for inclusion of their names in the seniority list. Thereupon, on 26/3/2018, the seniority list was published, wherein the petitioner's name, though were found at serial number 471 and 472, but a note was appended to the said list, wherein it was recorded that the persons at serial number 442 to 503 certificate course and others shall not be eligible for further promotion to the higher grade. It is also relevant to mention that subsequent thereto, by an order dated 28/11/2019, the services of the petitioners, along with other junior engineers, were confirmed by the Governor of Nagaland on completion of the probation period and on the recommendation of the State Medical Board. The note 3 appended to the memorandum dated 26/3/2018 have been assailed by the petitioner. We are assailing that only on the ground that the said is contrary to the weather rules. We've taken it back.
No, my lord, it should be on file.
Oh, contrary to the Nagaland Engineering Service bracket Group A and Group B bracket close rules 2012. For short, the rules of 2012. Inasmuch as Rule 7 stipulates the method of recruitment and the eligibility for the purpose of promotion to the posts have also been stipulated in Schedule Roman 7. Mr. A.G. Nomi, the learned counsel submitted, appearing on behalf of the petitioner, has drawn the attention to Schedule Roman 7 and submitted that to the post of subdivisional officer, assistant engineer, assistant architect, the method of recruitment is 60% direct recruit and 40% by way of promotion. The promotion has to be made from amongst the degree of the diploma holders in the concerned engineering discipline and who have completed a minimum of 7 years of continuous service in the immediate lower grade in case of diploma holders and 4 years in the case of degree holders on the basis of the merit cum seniority. The learned counsel therefore submits that a perusal of Rule 3(9) defines the term diploma to mean diploma from a recognized polytechnic or institute. He therefore submits that the petitioners, being diploma holders, admitted in mechanical engineering, as would be seen from the office memorandum of the memorandum dated 26/3/2018, the petitioners could not have been debarred from promotion. He therefore submits that the said Note 3 attached to the seniority list is required to be interfered with insofar as the petitioners are concerned. This court have duly taken note of that pursuant to the filing of the instant petition, an affidavit in opposition has been filed by the respondent state. wherein it is the categorical stand of the respondent state that under the Nagaland Public Works Department, the cadre department of civil engineers consists of PWD bracket R&B, comma, PWD bracket housing, comma, PWD bracket national highways, comma, PWD bracket planning and design, whereas mechanical engineers consist only of PWD mechanical. It has been stated that there are two separate seniority lists maintained, that is one for civil engineers and the other for mechanical engineers. The petitioner number one, who was initially appointed on contract basis on 15/6/1998, was regularized on 14/12/2006, whereas the petitioner number two was initially appointed on provisional basis, was regularized also on 15/6/2009. Also was regularized on 15/6/2009, 14/12/2006, and 15/6. It is the stand of the petitioners, of the state respondents, that the petitioners, being diploma holders in mechanical, were appointed under the Civil Engineering Department, PWD bracket R&D. And as such, the names of the petitioners have all along been reflected in the tentative seniority list as well as the final seniority list issued under the civil wing instead of the mechanical wing. It has also been mentioned that in Schedule Roman 7, serial number 6 of the Nagaland Engineering Service, bracket Group A and B, bracket, it has also been mentioned that in Schedule Roman 7, serial number 6 of the Rules of 2012, provides that the promotion to the post of the subdivisional officer shall be filled from amongst the degree of the diploma holders in the concerned engineering discipline. It was therefore the stand of the state respondents that as the petitioners were appointed under the civil engineering discipline but did not possess the diploma in mechanical discipline, their names are figured at serial number 41 to 471 and 472, with the remarks contained therein that they are not entitled to promotion. It has also been mentioned that the petitioners have not challenged the rules of 2012. Ms. Livita, the learned counsel appearing on behalf of the state respondents, submits that taking into account that a promotion to the post of the subdivisional officer can only be filled up from amongst the degree of diplomas in the concerned engineering discipline, the petitioners who were appointed to the civil engineering discipline wing cannot be granted promotion in view of they possessing a degree for diploma in mechanical engineering. This will put a specific query upon the learned counsel, state counsel appearing on behalf of the state respondents as to whether the rules of 2012 is applicable to both the engineers of the Nagaland Public Works Department, to both the wings, no? Wings of the Nagaland Public Works Department, and as to whether there is any provision in the said rules which stipulate that there shall not be any promotion to the post of and as to whether the same rules stipulate recruitment to the post of the feeder post on the basis of degree or diploma in the concern of a particular branch. The Learned Council, State Council submitted that the rules of 2012 is duly applicable. But submits that, that for promotion that for promotion, the degree or the diploma holders has to have the qualifications of the same discipline.
For entering the that your lordship, kindly on the rule for your, I mean,
Rule
for your lordship on the that your lordship.
Rule
Service rules for your lordship.
Hmm.
It talks about constitution and composition. Here your lordship has already taken a view on this, but it is written here on the last 5 column. A member of one cadre shall not be appointed or have any right for appointment to the post included in any other cadre, your lordship. Any officer in any
member
grade
of
shall
one
have.
cadre shall not be appointed or have any right for appointment to the post included in any other cadre. Then
Lordship,
I'm
go
not
with,
asking him to be sent to mechanical.
no, your lordship, but it is there, your lordship, but however we have actually wrongly or rightly done that, your lordship, but just making an aware
No,
of this.
understood.
Your
You say
lordship,
a
and
member of one cadre.
yes, your lordship.
Cadre means of a cadre of the civil, electrical, architecture, so and so, shall not be appointed or have any right for appointment to the post included in any other cadre. Means that if a person is there in the civil engineering who does not have a right to be appointed
Yes,
in
your
the
lordship,
mechanical.
in the mechanical.
That is what you are
Yes,
saying.
yes, your lordship.
So how is it relevant?
No, your lordship.
I'm not asking you to put into mechanical.
Your lordship, that I don't know, your lordship, but just making your lordship aware.
Now, your submission is therefore that he has to have the degree or diploma holders in the concerned engineering discipline. That is what your
Yeah,
submission.
in the concerned discipline, your lordship. Because in schedule, your lordship, schedule 3, we have a conditional course. There's a category statement of mechanical also, your lordship. Schedule 3, for mechanical, they have to get promoted to assistant mechanical engineer. But on the schedule 7, your lordship, when I inquire, it stated that this is applicable to the mechanical also. It is applicable to the mechanical also. So the next promotion was this schedule 7, rule 7, rule 6 will be applied. That is what I impressed.
Mechanical is.
Yeah.
Now, here assistant mechanical is there.
Yes, Your Lordship. In schedule 3.
But he can't go to mechanical
Yes, Your Lordship.
because of this.
Yes.
I've heard the learned counsels appearing on behalf of both the parties and have given the anxious consideration to their relevance to their submissions, respective submissions. From a hearing from the stand which have been taken by the respondents of debarring the petitioner from being promoted is that the petitioners have a diploma in mechanical engineering, whereas for the purpose of in the wing where the petitioners have been appointed, the concerned discipline should have been for civil engineering. This court have also taken note of the rules of 2012 wherein as per Rule 5, the services of the NPWD shall consist of different grades in each cadre which have been enumerated in Schedule Roman 1, Roman 2, Roman 3, Roman 4, Roman 5, and Roman 6. It is very pertinent to take this code finds it very relevant at this stage. That Rule 5 only takes note of rates and cadre service and has nothing to do with the discipline. The relevance of which could be seen infra while discussing the Schedule 6, serial number 6 of Schedule Roman 7. Rule 7 stipulates the method of recruitment and as per the said rule, the same shall be done either by direct recruitment or by promotion. It further stipulates that the qualification for direct recruitment, criteria for promotion to various grades of service, and the ratio of the quota for direct recruitment and promotion at each grade of service at the commencement of the rules of 2012 shall be stipulated in Roman 7, Schedule Roman 7. Now coming to the Roman Schedule Roman 7, this code finds it relevant to reproduce serial number 6. Which is reproduced here in under. It's then, no? A perusal of the same would show that 60% to be filled in the cadre of, in the grade of subdivisional officer oblique assistant engineer oblique assistant architect would be by way of direct recruitment from amongst the degree holders in the concerned engineering discipline of the recognized university. The remaining 40 are to be filled up by promotion from amongst the degree of the diploma holders in the concerned engineering discipline and who have completed a minimum period of 7 years of continuous service in the immediate lower cadre in case of diploma holders and 4 years in the case of degree holders on the basis of merit from seniority. The same provision, the same rule, the same serial number 6 of schedule 7 do not specifically mention as regards that an engineering do not distinguish between a diploma holder in mechanical with a diploma holder in civil engineering. Else, there would have been incorporation of discipline vis-a-vis the cadre. Unlike that, if this court takes note of the qualifications necessary for direct recruitment to the post of junior engineer, junior architect, system analyst, oblique shift engineers, which is the feeder post. There is a specific mention of a degree or a 3-year diploma in the concerned engineering branch recognized by the AICTE. In addition to that, therefore, in the opinion of this court, that when Rule 7, read with serial number 6 of Schedule 7, does not bar promotion of the post, promotion, consideration for promotion from the post of a degree or of a diploma holder, degree or diploma holder of an engineering discipline, of any engineering discipline, of a engineering discipline, more so in the instant case, mechanical. The respondents, when therefore not justified in debarring the petitioner's hearing from promotion, for consideration for promotion, by incorporating their names in note 3 of the office of the memorandum dated 26/3/2018. This court have also taken note of that the petitioners herein were initially appointed as sectional officer, grade 1, And sectional officer grade 2, petitioner number 1 and 2 were appointed as sectional officer grade 1 and sectional officer grade 2, respectively. Thereupon, they were regularized on 14/12/2006 and 15/6/2009, respectively. The respondents have regularized the services of the petitioner in the civil engineering wing cadre. And at that relevant point of time, it was never informed to the petitioners that the petitioners would not be promoted. And at that point of time, had regularized the services to the civil engineering cadre. Under such circumstances, now the respondent authorities, in the opinion of this court, cannot debar the petitioner for promotion, for consideration for promotion to the next higher grade if they are otherwise qualified on the ground that they have degree, diploma in mechanical engineering. The said actions, in the opinion of the court, amounts to be an action which is arbitrary, and unreasonable, which violates the mandate of fairness and Article 14 of the Constitution. Accordingly, this court therefore interferes with the note number 3, appended to the memorandum dated 26/3/2018, only insofar as the petitioners are concerned. The respondents are therefore directed to take appropriate steps in view of the above decision. With the above, the instant petition stands allowed.
For hearing, item numbers 4.
Mr. Inke, we just finish up the orders. Won't take much time.
For orders, item numbers 10 and 11.
Chief, I'm appearing on behalf of my senior TB Jamil.
4 and 5.
Yes.
They're paying for 6 to 45.
Yeah.
You are paying for 6 to 45.
Yes,
You are paying
We're
for
entering appearance for respondent 325 in WPC number 317 and respondent number 326.
okay. Now, what do you want?
I would like to seek time to file Vakalatama and also to file
You have not
counter.
filed Wakalatnama.
Yes.
And you have filed your Wakalatnama. It is written in bold letters. Learned Counsel for 6 to 45 has filed Wakalatnama. 45 has filed Wakalatnama. What do I do with that? You are saying no. That means we say that this Wakalatnama is not there. So we say this Wakalatnama does not exist. Where is the second file? Where is the second file? It is 317, 318. Where is the second file? Two files. Is it two files? 7. Okay. You mentioned that file vocality. Verification. You not file vocality. Oh, they mentioned that file vocality. Anyway, you are going to file. Have you filed your affidavit?
No.
When are you filing? 1 week? State? As a state file, madam?
No, Lordship, this is in connection with that other 11 that was listed yesterday from the police department. 317 is for 317 is UBSI, SI, UBSI, and ABSI, the higher grade. 40.
Oh, here the state has filed the affidavit.
No, Lordship.
Yeah, there is one affidavit filed in 318 for affidavit of service. Yes, state, you are not filing affidavit. So we allow this petition on the basis that the state has nothing to say. Yes, please say. Right?
For division. Respondent number, the main respondents are respondent number 2 to 4. In others, matters, if I'm not wrong, the authority file is.
Yes, Lordship.
So this will cover.
Yes, the one
We are
fixed
fixing
on
it
Thursday.
Thursday.
Yes, Lordship. So these are related constables and UBSIs appointed
But
through
we-
backdoor.
We have to give them.
Chief,
full
this is
time.
our first appearance. First appearance
You are,
for respondent 3 to 5 and respondent 3 to 6 and 3-1, WPC number 318.
you are appearing.
Yes, the first appearance.
You are filing affidavit.
We need 3 weeks time to file Bakalatama and also to file counter.
Wakalatnama, first of all, you have not filed the Wakalatnama, we consider it as non-appeal. Without Wakalatnama, do you have the power? Tell me. What is it?
Exactly.
You have no power. You say non-appeal for the response. And we fix this matter on Thursday.
The other one is fixed on Thursday.
Along with that, we fix non-appeal on behalf of the in spite of service. Without Wakalatnama, you can't appear.
Chief, I have instruction to appear.
You can't have instructions to appear. How can you have instructions to appear telephonically? Who called you up? Nobody. Who has instructed you to appear?
Chief, I am appearing on behalf of my senior.
He has instructed you to appear.
No, Chief.
He's your client.
No, Chief.
Then, how is it possible? Okay. It has been submitted by the learned counsel appearing on behalf of the petitioner as well as Mr. Counsel appearing on behalf of the respondent. State.
Respondent number 1.
Respondent state.
Yes.
That the matters herein are also analogous to the another should be the name. Yesterday matter.
Chief,
Analogous to the PPC number yesterday is this number so and so,
277
which is fixed on
Thursday.
6, no?
Day after
Thursday.
tomorrow, yes, Lordship.
On 6,
On
6, 2024. Accordingly, this matter again on 6. With the number,
Lordship.
yesterday it was there from 17 to 27, no?
Yes, 217 to 227.
For orders, item number 12.
Maybe his lordship.
Hmm.
Lordship, by order dated 4/4/2024. This honorable court has directed the petitioner to take steps on this number 5, this number 6 through justice service, lordship.
Respondent number 5,
That's number 5, Lordship, my apologies.
You have not
But-
filed your return service report
Lordship,
by affidavit?
I've been informed by the petitioner that number 5 is not residing in the present, the resident, the address given in the petition.
You want to withdraw?
No, Lordship, I may be allowed to take that publication.
Why?
Substitute. Lordship, because the petitioner could not serve the service.
Why?
Because the petition, respondent 5, he is no more residing in the address.
And how do you do it?
By publication, Lordship, substitute notice.
Where the respondent of 5 is?
Probably,
It is some matter pertaining to. He's not staying there.
Lordship?
He's not staying there.
No, Lordship. She.
She. 5, no?
5, Lordship.
Mr. Onse,
Proceed properly.
the learned counsel appearing on behalf of the petitioner submits that although the petitioner tried to take steps upon the respondent number 5, but the respondent number 5 is no longer available in the address. Under such circumstances, the petitioner submits that he would like to take substitute the service upon the respondent number 5. Taking into account the above, list the matter again on the 6th of July 2024. In the meantime, the petitioner is directed to publication, publish, and issue a paper publication routed to the registry of this court on or before. It's on 26, no? 26, on or before 24th of June 2024. Lordship published.
Lordship is the interim.
Interim order custodial shall continue till the next.
I'll oblige, Lordship.
Yes, you are nowhere to be found when a mere matter is called. But you don't have juniors.
No, Lordship.
You have so many matters.
Lordship, some of them are
If
on.
you are not helping out the juniors, who is going to help? Or you want to take the everything?
Some of
to
them are
yourself?
on leave, Lordship, for
Or
various
you don't
reasons.
want to share your
It's not like that, Lordship.
bounty.
No, in fact, I have 7 to 8
Something like that.
juniors.
Doing that. He doesn't want to have a junior.
No, in
You
fact,
have
I
so
have
many
7,
matters.
I have 7 to 8
Or
juniors.
are you
Lordship.
spending half of your money out there on the PIs? Something like that, right? You're
Like that,
nowhere to
Lordship.
be seen. You don't have a junior and you have so many matters. Yes. Orders?
For orders, item number 13.
Lordship, here I am appearing for respondents 1, 2, and 3, Lordship. Items 13, 14, and 15, Lordship, they are similar, Lordship. The parties are also same, Lordship. And
Land acquisition?
Yes, Lordship.
yes, Lordship. I filed my
What are you doing? What are you challenging? What are you challenging, madam?
The prayer,
I'm-
Lordship, is to acquire the land as per
Yes,
the
Lordship,
NHI.
as per the.
That's the
How
habit.
can we direct the state to acquire? Have they taken over your possession?
However, Lordship, it has to be acquired as per the law, Lordship.
Understood, very well. But have they taken over the possession?
Lordship, they have already, the work has already begun, Lordship, the construction of the national highway, Lordship. So
They have not-
without acquiring the land, Lordship,
So no,
How can-
therefore, they have taken over the possession of your land.
yes, Lordship,
Yes.
the construction has already begun, Lordship.
My lord, the state of Nagaland is so backward in the sense we don't have proper good road. So in order to have good road and to have faster development for interstate connectivities, the state has come up with a policy
Huh?
that damage compensation will be paid other than compensation. That was the
They
decision.
will give what?
Damage compensation.
Service.
Damage.
A damage.
Yes, ma'am.
Okay.
Other than that, no name compensation.
Then? But, can you do so?
I mean, we given 3 weeks time. For
Can you do that?
obtaining
Maybe
instructions.
this right to fair compensation, whether it is applies to the state of Nagaland, is not known. But most pertinent, madam, have you gone through the recent judgment of this? Very beautiful judgment. I think that will be required for you. The very beautiful, I think one of the most beautiful judgments on land acquisition. Yeah. Kolkata Municipal Corporation and another versus Bimal Commercial. Is a judgment recently by Justice Narasimha. It says a very important judgment. Why I'm saying so? Say this is your right, which you are asking is a right under 300A. It says the right under 300A has 7 essential conditions which require to be fulfilled by the state. The first is the right to notice, right to be heard, 2, right to a reasoned decision, 3, duty upon the state only to acquire for public purpose, 4, right of restitution of fair compensation, 5, the right to an efficient and expeditious process, 6, and right to a conclusion of the entire process. This is the judgment. I give it to her. Take it up.
Lordship, obliged.
This is a very recent judgment. 16th of May 2024. This is your
Lordship, obliged.
Kolkata Municipal Corporation. You are good.
I am preparing for the union lordship.
So you are not to pay actually. So who are you? Means who is taking the land? It is a national highway.
Yes, Lordship.
Then the payment has to be made by you.
Yes.
Why is the state?
To the state.
Even otherwise, your lordship,
Whatever
we are
may be
only
the
a supervisory agent.
The state will get some compensation, same amount of commission.
Yes, ma'am.
State has no business out there. You only pay the state some commission. You have to pay. Why you are not paying? Oh,
The Nagaland State Lordship, they have come up with the policy lordship.
what policy? Their policy has nothing to do. It is you. The state.
That's
We take up next week itself. He has filed the affidavit.
yes, Lordship.
On this
Yes,
judgment
Lordship.
itself, you can look into this judgment, you pass the order. They have a lot of money. State of Nagaland has no money, but they have not.
Yes, Lordship.
Lots and lots of money.
Lordship, there are other 3 similar matters, Lordship, filed by the same advocate, same stretch of Lordship. That is WBC 12, 15, and 16. If all of them can be plugged together.
Yes, Lordship.
You dispose of them together.
Yes,
We directly, give them money, we help you out in saying that Nagaland has no money. Okay, Nagaland is considered that. But the thing is, if they are entitled to, has there been any award passed? Then how did you take their land? You are going to acquire for them, from them. Without acquisition, you cannot take the land.
I'm yet to receive instructions.
You may be. Have you taken their land or not? You are not to pay. There's no quarrel that you
Yes,
need
ma'am.
to pay.
Yes, ma'am.
You will get however contingency amount from them. And look here, you are paying them. Just the more you pay, the more is your commission.
Yes, ma'am.
If you pay them 1 crore, it's always 8%. 8 lakhs is yours. You pay 100 crores, then it is 8 crores. So therefore, do something. File your short affidavit.
The only thing that state is only a supervisory agent, which is central project.
It's not a supervisory. They cannot acquire the land. The acquisition has been made through you.
Yes, ma'am. Yes, sir.
So you will acquire the land
Yes, ma'am.
and pay, get the money from them.
Yes, ma'am.
So I'll have to pass an order
Yes,
out
ma'am.
here that acquisition process, if not done, shall be initiated
Yes,
forthwith.
Yes, ma'am.
And they should be paid their dues. And then keep the matter pending for some time so that you get some money. We'll have it next week. You just get your instructions.
Yes, ma'am.
What is the status of
Yes.
this as to whether the petitioner's land has been taken? That's all. We don't want you. And if you can file a short affidavit, yes, nothing to do with anything else. Only the government of Nagaland is going to say, if their lands have been taken, but no compensation has yet been. That's the only 4 lines affidavit. Mr. Swain the Learned Council appearing Learned Additional Agent submits that we will file a short affidavit in the matter, which taking into account the urgency shown by the Learned Council for the petitioner. This time is going to be listed again on when, madam?
Tuesday, 11 Lordship.
11th of June 2024. You take out that jet.
Lordship,
It should be here.
Yes, please, madam. What's with my presence?
Yeah. Mr. Swansea, the Learned Council appearing on behalf of
Respondents one, two, and three.
submits that there are 3 more matters being also there. So the number of the same matters being the application of the sponsor, we listed along with the instant. These are 3 matters, no?
Yes, 3
Instant
matters.
batch of the petitions on
Much obliged.
For orders, item number 14.
14, 15, same.
13, 14,
15 also.
Yes, ma'am.
For admission, item number 48 to 49.
So this is your method. Yes, tell me. What is your case? What you are asking for?
241, WTC 241 of 2016.
241.
Yes.
241, yes. A writ in the nature mandamus should not be issued directly there to conduct and complete the investigation with respect to the death of Valentin who died at the lockup. We refer the matter to the Central Bureau of Investigation and the commission appointed by this court to oversee the investigation to be carried out. Then what happened as regards the other? There's another matter. What is
The
this?
other
What is
other
the
one
second
is,
metaphor?
Yes.
Within the mandamus should not be issued directing insurance for payment of compensation of this 10 lakhs along with interest from the death of friends. Okay, so this is the death out there in the lockup. Death in the lockup.
Malo.
And as such, one petition is for further inquiry.
Inquiry, Malo.
And the second is for the purpose of compensation.
Malo.
You're responsible.
I'll try to satisfy this.
Huh?
Satisfy this.
Yes, please. How did the person die in the lockup?
Lordship, the petitioner has actually first satisfied this court as to as to how torture has been meted out. Because Lordship, the petitioner has adequately stated that torture has been meted out to the accused, to the accused deceased, and because of the torture meted out to him, the petitioner, the accused committed suicide in the custody. However, the whole
The
story is
accused committed suicide in the
yeah,
custody, in the lockup.
yes.
How?
Your Lordship, he was arrested on 29th evening, Your Lordship. 29 evening.
So at the on 29, when you made the you arrested him.
Yes, arrested him.
And then you put him in
He
the
was
lockup?
actually firstly apprehended by the public, Your Lordship, because
Okay, very
yes,
well, understood.
yes.
Then he was arrested.
He was arrested on 29th and
Okay, now
on 34th.
let us not go so far.
Okay.
On 29, when he was arrested, did you do his medical?
Yes, Your Lordship.
What they was there? Medical.
He was under intoxication and due to public
As
handling.
regards his injuries, what is the medical report?
Yes, Your Lordship, due to public handling, there was some aggression on the eye, on the right side of the eye, and so some medicine was prescribed. And after medical checkup, he was sent to the magistrate for 24 hours remand. So after that, the next morning, he committed suicide.
How?
Lordship, it's all the video clipping is there. The original report has been called for by this honorable report, and I think it is a right, Lordship. So everything is there. The report inside the lockup, except we cannot capture the toilet, Lordship, because the camera is not inside the toilet.
So this camera had a CCTV?
Yes, CCTV.
The police station had a CCTV?
Yes, Your Lordship.
Then with the CCTV being there, how did he commit suicide?
Yes, Your Lordship. There was some commotion going on inside the bed and like maybe
He committed suicide only in the morning.
Yes, in the morning. So in the
What
morning
time?
only. Your Lordship,
Let's see your certificate. "23-year-old dead body received."
Your Lordship, since
Where did this happen? Here in Nagaland.
Kohima.
Why letter was written to Sarvananda Sonowal?
You are from that area. The deceased was working here as a mechanic foreman.
Where's the postmortem?
Postmortem was never handed to go to
Age of
the
injury
family.
is 2 to 3 days ago. Time since death 4 to 6 hours. Death was due to hanging. How did he hang? In the lockup?
Yes, Your Lordship, as you see the clipping, Your Lordship. In the morning, like he was just kind of restless.
Who gave the rope?
The rope, it's not a rope, Your Lordship, but it is torn from the bedsheet.
Huh?
From the bedsheet mattress, Your Lordship.
Battery?
Mattress, Your Lordship. The bedsheet he was
Oh,
wearing.
bedsheet.
Yes, so some commission we couldn't even ascertain that it was taken from there because it was there was some commission on inside the bed, Your Lordship. because he was covering his body with that sheet, your sheet.
How big is your lockup?
So it's very small, your lordship.
Understood.
Yeah.
In a lockup, how many people remain
Your
at
lordship,
a one time?
one.
Only one. It's so good in Kohima. Only one lockup.
No, your lordship, he was confined in one room, your lordship.
They cannot be. Never heard of.
Your lordship, if it would be good if your lordship see the CCTV.
Where is the
footage.
CCTV?
Your lordship, the original reports has been sealed paper.
How can there be no one lockup? I mean, we have to ask the police who has the. Has the police filed any affidavit?
Your lordship, there was a magistrate inquest report.
Ministerial inquiry is okay, but has the police filed an affidavit to that effect? To the effect that that person who was in charge at that point of
Yeah,
time,
everything, the statement has been recorded and it's signed.
only one person. How many lockups were there? No photographs. Mr. This is a system. How do you put nowadays this thing? How do you put it? Nowadays, do they have still this in computers? Yeah. You have the technical procedure. Coming in 5 minutes, okay? Let them get ready with this. And the magistrate made an inquiry
Yes, sir.
with whom?
To on the custodial death, your lordship.
We may have to have an inquiry, but visiting an inquiry by a person of a in Kohima, we asked the district judge to do it, submit a report before this court. I mean, 5 minutes.
Ui,
Itu Paulus.
When was his body found?
On 31st itself, Your Lordship, on the morning, in the early morning, Your Lordship, all the duty was done. He has done his nature call and all these things. At that point of time, also he was okay, Your Lordship, as per the CCTV and as per the statement of those police officers who were in charge, Your Lordship. They rushed inside and it was found hanging, Your Lordship. And when they put him down, there was still
So
some.
this happened from 8 to
There's
8:25.
somewhere between.
So the accused knew that you are going to change your guard at that point of time. How is it possible? Looks like something is wrong. He did not do anything till 8 o'clock in the morning. He was fit and fine. There was nothing wrong seen out there. At 8:25, when the next person comes, he sees that he's dead. That too with bed sheets. What were those bed sheets doing?
That
You
is,
have bed sheets in the lockup.
then how will he sleep, Your Lordship? He has to come himself for sleeping.
So, madam, have you visited the lockups? Ever? Have you seen the lockups? There's no bed sheets out there. There's no beds out there in the lockup. Is it? Isn't it? Is there any bed sheets in the lockup?
Your Lordship,
Never.
Your
I've
Lordship,
never heard about it.
Your Lordship, if you can kindly see the CCTV, Your Lordship.
I've seen many lockups up there in the Gauhati. There's never a bedsheet. The picture of bedsheet does not arise. And one person remaining in the lockup is also not heard of. And in fact, this magistrate did not put that query out there as to how many people were there. How many people were there on that day? How many people were seen out there, arrested on that day? You arrested him at 125 hours on 28. You produced him on 38. 38, are you saying that how many lockups does the Kohima police station have? How many lockups?
Your Lordship, we have two police, not in South Police Station.
Hmm?
Not in South, Your Lordship.
There are two lockups because
Yes,
one is for male and one is for female.
No, we have two, Your Lordship, not in South, if I'm not mistaken. If I'm not mistaken, Your Lordship, we have two. One is at the north and one is at the south. Not just nearby, Your Lordship, and this incident happened in the morning.
There were two lockups.
Yes, Your Lordship. If I'm not mistaken, Your Lordship, subject to confirmation, Your Lordship.
Mr. Longshore, have you in fact how many lockups were there in this particular police station?
Within Kohima city, there are two police stations. If I'm not mistaken,
It was
one
in-
lockup base.
In which police station it was?
This one, this is the south.
Oh, sorry, south.
This police station.
This
Yes.
police station.
How many lockups are there?
I'm not sure, but I've seen only one.
One lockup.
Yes.
But this happened in 2016. Now, when 2016, 2016. Now the question at that point of time is how many lockups were there? This is a very vital
No,
aspect. of the matter.
it is still the same. One aspect of the matter is
And did you have how did he go into that ventilator? How did he climb to the ventilator?
Your Lordship, as per the statement, it was, Your Lordship, the explanation that was given was, it is not very high.
If it is
was
not
on the
high,
window
then
grill
obviously
only,
he
Your
cannot
Lordship.
hang. If it is not high, he cannot hang. If it is high, how did he go and
Your
high,
Lordship,
get to that height?
Your Lordship, as per the statement, Your Lordship, when they went, like, he was not totally like, out of breath, Your Lordship, there was some, still that breathless ability.
that struggling was going on. So they put him down, they brought it in outside the cell, and they tried to revive him, Your Lordship. That is also there. And they took him to the NHK, Nagar Hospital, Your Lordship. But by the time they reached the Nagar Hospital, like he was brought there, Your Lordship. And she was there, Your Lordship. He was not fully there, Your Lordship.
What is that? They have not put that. I you see that on that where is that video? That video is not here.
We will be having two videos. One will be the CCTV footage of the cell, and that will be the post-mortem.
So then why the CCTV footage has not been placed before this?
No, I think it should be there because since
No,
I have
only
the
one
copy
disc
with
is there. No CCTV footage. That is the CCTV footage. That is there in another TV. Is this the manner in which the investigation has been carried?
I have the copy, but it's not upside down, so I have to see like this.
Upside down, he can make it this way. That is not a problem. But it is actually they have taken a video of that photograph. You have the CCTV footage.
Yeah, I have the CCTV.
Just take it out.
No, sure, but it's not like very like
Who is the magistrate who made the inquiry? Magistrate inquiry doesn't say anything. See, the magistrate's inquiry says multiple ligature marks were found on the front neck.
Yes. Yes.
Now, the postmortem inquiry says age of injuries to be 2 to 3 years, 3 days from the time of examination.
Yes, Your Lordship.
How do you gel both together?
No, Your Lordship, but if we see the on the other column, Your Lordship, on the left side of the column, we can see the indicator, a mark, place, everything is written there. But as far as the injuries are concerned, it is 2 to 3 days old. There's some small marks, Your Lordship, on the hand, because if you see the postmortem, we will see that there's some marks on the hand. And so that indication of that marks is 2 to 3 days old. Otherwise, everything is written on the left column, Your Lordship. Left side of this postmortem, Your Lordship.
We do one thing, Mr. Answer. We ask the district judge to make an inquiry and submit a report according to this. And on the basis thereof, we well, otherwise, these certain findings I can't do, although I'm not satisfied with the manner in which currently appears to be something. They have not, the ministerial inquiry did not even consider what was the height of the ventilator. Whereas if the height of the ventilator was such, how did he get on the hold of that going to the top? Because there is obviously, I don't think there are windows in the locker.
Lordship, that I also
Obviously,
personally
there is no.
inspect, Your Lordship.
Don't tell me there's a windows also in the lockup.
Your Lordship, in obviously, I think there should be some things so that the
How did he
guests
go
can
on
go out.
lockup? How did he get a cloth? Unless he has used his clothes. And that magistrate inquiry does not say so. That whatever he was wearing has been used. Where did he get the clothes? That's the point.
In the inquiry report submitted by the Superintendent of Police, it's written that this
Not
report
at
was
all
taken from.
satisfactory.
Lordship, that is the case.
Both the repetitions. Of Mr. I, the learned counsel appearing on behalf of the learned state council, appearing on behalf of the respondent, and who? What is that?
CPI.
And Mr. Swenson, the learned counsel, representing the Central Bureau of Investigation, the learned counsel appearing on behalf of the union. The number 421 or 241 of the 2000A of the 2016 have been filed. Seeking an investigation into the death of late Jalaluddin, who died in the lockup at South Point Police Station, Kohima. Either by the Central Bureau of Investigation or by instituting a commission to oversee the investigation to carried out by either by the Central Bureau of Investigation or and to institute a commission and to appoint a commission to oversee the investigation to be carried out by the respondent authorities. WPC number 120K of 2017 is a petition seeking damages on account of the death of Late Jalaluddin in the lockup, on the basis that it is a constitutional tort which has been committed by the respondent state authorities. From the materials on record, it reveals that at 1:25 a.m. on 29/10/2016, late Jalaluddin was arrested by the police station, by the officials of the other time. Where are the other people? Where did you put it? Official. Was arrested by the officials of South Police Point, South Police Station, Kohima. Thereupon, the Said Jalaluddin, at the time of his arrest, late Jalaluddin hands were tied up with minor injuries. Thereupon, after arresting, he was sent for medical checkup, and when he was brought back from the hospital by 300 hours, at 300 hours, 0300 of 29/10/2016. On the next day, on the same day, he was produced before the magistrate and a police remand was obtained for 24 hours. It is also seen from the reports that late Jalaluddin was interrogated at 1700 hours. And as there was no headway into the interrogation, he was asked to return back to his cell. It is also seen from the records, and more particularly the case diary, that till 800 hours of 30/10/2016, late Jalaluddin was found fit and fine inside the lockup. And the same, as claimed in the case diary, is proved by the CCTV footage. Before further proceeding, this court finds it relevant to observe that a compact disc has been enclosed to the instant is enclosed to the documents and is enclosed to the records sent by special messenger on 19th of February 2024. The same in the same records, there is a compact disc and the detailing in the same compact disc is far from being satisfactory. Be it as it may, it is also seen from the case diary that at 0825 hours, when late Jalaluddin, when late Jalaluddin was when a new party checked the cell wherein late Jalaluddin was confined, they found that the cell was empty, and upon entering the cell, late Jalaluddin was found inside the toilet with a piece of cloth tied around his neck and the other end tied to the ventilation grill above. It was also mentioned in the case diary that a body was facing and leaning against the wall with the tip of the toe touching the floor. Thereupon, the body was removed from the toilet. No, thereupon, late Jalaluddin was removed from the toilet, and an attempt was made to revive as his body was still warm. And he was making a low guttural sound which was emanating from the throat. Thereupon, late Jalaluddin was immediately rushed to NHAK, where the doctor on duty declared him drop dead. On the basis of the said death which happened, a magistral inquiry, an FIR was filed which was registered as FIR number 17/16 under section 302. The said FIR was filed on 4/11/2016. And a GT entry was made on that very date. But surprisingly, the said FIR was registered on 16/11/2016.
Lordship, here we have two FIRs, Your Lordship. So,
FIR. I
yeah,
see.
one is FIR was lodged after Your Lordship. That is from the Assam, Your Lordship. They lodged an FIR. The first
Madam,
FIR is
Madam, the records show this FIR complainant Lukman Bin. Then this is the original FIR. This FIR says it was received and the officer in charge has made it a GD entry on 4/11/2016. And this was registered on 16/11/2016. The record further reveals that a final report was submitted in respect to the said FIR. On 8/8/2017, by the officer in charge of the South Police Station, Kohima, opining that there was no foul play involved in the part of the PS personnel on duty, and the and late Jalaluddin took the extreme step of ending his own life on his own volition. It is also seen that on 19/5/2017, the final report was prepared, which is dated 8/8/2017, signed by the Deputy SP, Subdivisional Police Officer, South, Kohima, Nagaland. Also opining that there was no foul play seen. It is very interesting, however, to take note of an aspect recorded in the said final report that the material, the bracket, the piece of cloth, wherein it has been stated that the material bracket piece of cloth used by the late Jalaluddin to hang himself appears to have come from parts of the bedding materials supplied to him. Though in the entire final report or the case diary, there is no mention of late Jalaluddin having met any person during at the time when he was in custody. This court have also perused the magistral inquiry report dated 30/10/2016, which under no circumstances can be said as a report investigating the a report which by which the said magistrate had duly inquired the custodial death of late Jalaluddin. The said report is only a magistral inquest report. Let's go. Upon perusal of the materials, on the basis of the final report, on the basis of which the final report has been submitted, is of the opinion that the inquiry which have been conducted, investigation which have been conducted, does not seem to be taking into account various aspects as to, just for example, was the was late Jalaluddin alone in the lockup? How many persons were remanded to the, how many persons were there in the lockup? How did the, how did late Jalaluddin get a copy, get the material cloth which was used for, which was used in the alleged suicide committed by late Jalaluddin? The postmortem report is also not satisfactory. Inasmuch it only merely states what are the injuries and does not take into consideration, and the final report also does not take into consideration as to how Jalaluddin was able to tie the cloth to the ventilator of the toilet. If the ventilator was of a particular height, and if the ventilator was of a lesser height, which is apparent in as much as late Jalaluddin's feet was also touching the floor, as to how such an injury could have been caused to his neck, which would have led to his death. The FIR which was filed on 16/11/2016. It is also seen that on 16/11/2016, another FIR was filed. No, no, no. It is seen from the FIR, which was filed on 4/11/2016. That it was specifically alleged that in the CCTV, what is seen was only the body of late Jalaluddin being brought out from the cell and nothing inside the cell. The CCTV footage which had been placed before this court does not show anything. It's not. It does not give also a clear picture. And if that be so, how did the investigating officer come to an opinion that he had based his opinion on the CCTV footage? From the case diary, it is also seen that the incident happened as per the police person during the period from 8 to 8:25 of 30/11/2016, 30/10/2016. And during this period, why the police persons who were in charge did not notice that that late Jalaluddin was not in cell. All these amongst the many are required to be inquired with. For that, there is a requirement of a fact-finding inquiry. Which this court, in exercise of the powers which this court under such circumstances, this court, therefore, directs the district judge, Kohima, to carry out a fact-finding inquiry as regards the death of late Jalaluddin. and submit a report before this court. Written. Within 3 months from the date of receipt of the instant order, along with the papers enclosed therewith. Before this court. Before this court, within 3 months from the documents which have been placed before this court by the Chief Judicial Magistrate Kohima in a seal cover. We also sent to the learned district judge Kohima as the same may aid the learned district judge in conducting the inquiry. The registry is directed to send a copy of the instant order to the learned district judge Kohima to carry out, to take appropriate, so that the learned district judge is in a position to take appropriate steps in that matter. This court further directs the superintendent of police, Kohima, as well as the officer in charge of South Police Station, to provide necessary assistance to the learned district judge for conducting the said inquiry. The learned district judge, for conducting the said inquiry, shall have the due powers as a commission of inquiry to list the matter again.
Lordship, you can even the CCTV footage, Lordship, if it can be produced, the original CCTV.
Huh?
The original CCTV footage.
Yeah, it is there. This is the
It's
original
original.
CD. That is what I am looking into. This is the original CD. That is where you have the original FIR. FIR was filed on 4/11. It was registered on 16/11. Initially, it was registered as a 0 FIR.
No, Your Lordship, we have an FIR, Your Lordship.
That is of 16/11.
No, no. 16/11 and another one is 4/11.
4/11 was made, recorded as 16/11. When it was given as 4/11, it was recorded as 0 FIR.
Second,
There's no 2 FIRs, 1 FIR.
no,
They
no, two
cannot be-
FIRs. One FIR was lodged by a complainant because theft
That
happened.
is
in
the
his house.
FIR of 4/11.
Yes, Your Lordship.
That was initially put as the GB entry number 67
Yes, Your Lordship.
and also recorded as a 0 FIR.
Yes, Your Lordship.
Although the 0 FIR concept was not there, now we are going to have it. We have the 0 FIR. So the 0 FIR was put as a 0 FIR and was registered on 16/11. Therefore, you find it out there.
Yes, sir.
I also thought that there were 2 FIR, but the contents of both are same.
Your Lordship, just
This is the matter again on 14, 28, 2024. Maybe 2 months old. Right? How much? June. We have to have it in September. Huh? September 20, 29, 2000. Call report.
Your Lordship, let this copy be furnished to me, the order of this.
Yeah. copy of this order be furnished to Ms. for the State Council for doing the needful, for taking appropriate steps as regards informing the superintendent of police, Kohima, as well as the officer in charge.
For hearing, item numbers 16 to
Mr.
18.
Long, sir, in fact, your matter should have been given more prominence at that point. Your matter should have been given 2016. We are 9 years down. I mean, which the matter has been adjourned. This order should have come then. In fact, there is a way, I passed an order. Have you seen about the handcuffing? I passed an order. There was a advocate who was handcuffed in Gauhati. He went to lodge a complaint. There is another police personnel who also lodged the complaint. So there was a dispute between them. So what happened? The police saw him that look here, this person concerned, he was an advocate. How dare you say anything against the police? So what he did, he handcuffed that person. And then it was just a parking dispute. Handcuffed him and took him to the court. And then again, he was not granted bail. He was handcuffed and taken back to the jail. He thereafter got relief. He was also got acquitted in that case. Then he filed an application before the Assam Human Rights Commission for the purpose of getting compensation. He got the Assam Human Rights Commission said that that person concerned is dead, the investigating officer. So we are not going. Matter came up in writ. So the delayed matter, nothing happened, but that matter came up. And taking into account the judgment of the Supreme Court in there are two that is very beautiful judgments. One is of Justice Krishna, and there is another judgment of Citizens of Democracy, which is another judgment, wherein it has been held that you cannot handcuff a person unless you follow this, because iron checks should not be done unless it is more than necessary. And not only that, you are also required to record your reasons in your case diary why you have to handcuff, and then produce it before the magistrate. And the magistrate there have to give the concurrence, then only you can put the record. This is the Supreme Court judgment. So this was not done. Now, during the trial which was going on as regards that case, that investigating officer said that yes, I have handcuffed. There was nothing placed in record. So under such circumstances, I have granted a compensation of 5 lakhs for that. Your case is also good for that purpose. That has been how many days? It's thicker than the petition for the sheet. For such a long time.
Said, otherwise it was filed right in time.
You filed it rightly on time. But the sad part is due to the court's delay. And more particularly, at that time when you filed it, they did not submit the final report. Final report was submitted on 8/8/2017, whereas you filed the petition in 2016. At that point of time, some urgency was taken up into that.
Much obliged.
Yes.
16 to 18.
It is Lordship. Lordship, I have to mention on behalf of Deepak Home Lordship.
Who?
Deepak Home Lordship.
Deepak Home.
1 week time, 20 to final return the affidavit Lordship.
And exactly the same submission was made on 27th. 1 week time to file it. Okay? The students who learn the government advocate for the state pays for 1 week's time to file return. I'll say a repetition of the earlier prayers. Why did you ask Madam, you have no urgency.
Lordship, that's not the case.
Here
but-
also. What is? Huh? Petition is small. Ownership is this big. So your case is covered by that judgment. The division bench judgment, which they are going to file an SLP. Is that the matter?
Lordship, here, the petitioner's husbands and fathers, they died while performing bona fide government duty.
What?
They were in the power department and they died due to electrocution, Lordship.
Electrocution.
Yes, so they were work charged employees, but they died while performing duty. So that's the case, Lordship. And they were asking for extraordinary pension.
Extraordinary pension.
Yes, Lordship.
But you are not regularized.
Yes, Lordship.
How do
Not
you get
really.
extraordinary pension?
Lordship, this,
we have
we have a
moved to-
covered case, Lordship.
Huh?
We have a case that covers a similar. However, in the other judgment, it's of this honorable court only. The petitioner's husband was a contract employee, and he was while on his way to duty, he died in a bus accident, and he was granted extraordinary pension. So that's one of the cases that covers.
Have you got the money? Have you
No,
got
no.
compensation?
No, Lordship.
Why you are not paying that compensation? Okay. Electrocution compensation you have to pay. It is, do you have a regulation as per the Electricity Act? No, you are appearing for the regulation. Accountant General can't help. You are there. You are going to help me.
I'm not in this matter, Lordship.
Then none appears for the state. None appears for the state. What are you? You pass over. You can keep on asking the same thing, the same prayer. See, 15/4/2009, Mr. Influencer Learned State Council for area pays for 3 weeks time to file additional affidavit. Ms. So-and-so makes a mention on behalf of Mr. E. Pujapong, learned government advocate, and seeks for 3 weeks time to file rejoinder to the affidavit in reply. So-and-so appears for a year. Okay. To do one thing, we have been suffering from 2000.
Lordship, this is a second. This we went for the first petition and
From
then
10/8/2023, you have been suffering from on account of Mr. E. Pujapong. Yes. We do one thing. We impose a cost upon him, 50,000. Yes, yes. This is my normal habit out there in the principal seat. And then to pay to you, not to you, to your client. Something will happen. Until he doesn't pay, his license will be suspended. Yes. Nothing doing. Madam, you can't take this court for granted. I have a serious habit of imposing cost upon the lawyers. You want the judgments? See judgments in the I can send you 7 or 8 judgments where I impose cost upon the council. And to deposit it, else his license will be kept on suspension till he doesn't declare. Anyways, he's always taking time. He doesn't have to appear. He doesn't appear. He doesn't need the license. Take this code for granted like this. Why he has not got the electricity amount? Our department, we are entitled to that. Where about the other things? Why he has not got that amount? And file this. People will lose faith in the judiciary if these type of things happens. And the common advocate takes time like this. What is this additional attorney file?
Lordship, that's the seniority list.
Your name is there?
No, Lordship, my name is not there. My juniors have all been regularized.
Pursuant to your debt.
Yes.
Pursuant to your debt.
Some, Lordship, yes, pursuant to my debt.
But has there been any cases where a person who is not regularized or a work charge is regularized if he dies on account of electrification? Others is okay. Other amount you are entitled to. How do you take care of this? Yes. And we are not concerned with Mr. Yes. We are not concerned with it. It is the state matter, so all state councils are responsible.
Lordship, if the last chance, we will find it.
You.
And file it.
You appear. And you get your instructions. Why is she not entitled? Others, it's okay. Regularization is a very difficult thing. But as regards to compensation, why he not? Because that is otherwise entitled. Ms. Eshan, the Learning Council appearing on behalf of the state respondents shall apprise this court on 7/6/2024 as to why the petitioner hearing would not be entitled to the compensation upon his death. And why the petitioner hearing would not be entitled to the compensation on account of the death of her husband. Her husband.
Lordship, in WPC 69, it is the husband. WPC 70. There
Who
are
are
three
these?
connected matters, Lordship.
Well, all these are different matters.
They're analogous, but the petitions are different, Lordship.
All are different.
Yes, but all died because of electrocution.
Okay. Shall apprise this court on 7/6/2024 as to why the petitioner's hearing would not be entitled to the compensation in terms of the Electricity Act 2003. The registry shall show the name of Ms. S. Shah as the council appearing on behalf of the state.
Thank you.
Now you have been specifically assigned. No more mistake. No. Yes, yes. Yes, Mr. Counsel, what
For
happened to
hearing.
that excommunicated matter? Your matter. You were there, na? What happened to that? Suppose. Huh?
Excommunication right has been quashed by this honorable order.
Quashed.
Yes.
Subsequently.
The lordship has passed the order.
I didn't do that. I see that some other day. I didn't do that. But did I? No,
The
I
earlier
didn't.
occasion, when your lordship was
Earlier,
sitting.
I was thinking of the matter, but could not pass that order, I suppose.
I'm not
I
mistaken,
asked
lordship
you-
passed the order. If I'm not mistaken.
I was just thinking. Okay. We call it for a day today.
Item 25.
That will be taken up on 7th.
What is that?
The British to Commissioner appointment. 6th or 7th.
Hmm?
Either on 6th or 7th.
7th.
Yes. I can 55.
You want to do it on 7th?
7th was short middle. That's a long pending case.
You still have 5 minutes.
Yes.
Nowadays it is from 10:30 to 4:45. Yes, matter looks big, but what is the short matter about it? What is your repetition? Compassionate appointment.
Yes, Lordship. This is scam, Lordship. Lordship, as per the scam.
Huh?
As per the scam, Lordship, this is scam formulated by the state government for conventional appointment. And as per the scam, Lordship, commission appointment should be made on regular basis. On regular basis. And in terms of the scam, Lordship, the commissioned appointment should be considered on the basis of the date of the government acknowledges. That with regard that pertains to seniority when there's more than one applicant.
You claim to be on the basis of what?
From the date of the husband,
Date of
my husband. Lordship.
husband.
Because Lordship, my husband died in the year 2013.
13.
Yes.
And
And the respondent number 7, father died in 2017.
15.
17 Lordship.
Then how did it happen? You have a, do you maintain a serial wise on the basis of the date?
So Lordship, what happened in the year 2014? In view of non-availability of a regular vacancy, the petitioner was accommodated on contingency basis, with the condition that my contingency service shall be regularized as in when regular vacancy arises. So when a regular vacancy arose in the year 2017, instead of considering my case on regular appointment and commissioned ground, the respondent number 7 was appointed
On compassionate.
and commissioned. That's the short.
I heard this where it is matter came out. So you have similar type of matters, so many.
Yes, on last submission, Lordship, Lordship also heard this
Ah,
matter.
I think so. I remember something like that. Yes, how is it possible? Your submission is to the effect that look here, he is now already there, accommodated there, and as such, he lost his chance. That is your case, Jimika.
Lordship, what happened here is that, Your Lordship, this matter was initially taken up by one of my colleagues, Your Lordship. Meantime, I took it up, Your Lordship, and it has come to light that, Your Lordship, initially, when the petitioner's father died, they applied, Your Lordship. There is no specific reason that it has to be by completion. And the completion can be applied, but entirely okay, Your Lordship, they applied, and accordingly, Your Lordship, since there was no vacancy, the petitioner was appointed
As
on contingency, Your Lordship, not on regular basis. Now, meantime, Your Lordship, in the year 2017, Your Lordship, a vacancy arose, Your Lordship. Now, at that time, again, the petitioner applied, Your Lordship, under compassionate scheme. But at that time, the respondent has already applied for the petitioner. So, under that impression, the government has actually appointed the respondent number 4, Your Lordship. So it is not like it was completely miscommunication, Your Lordship. This appointment was made.
how do you take care of it? How do you
Now, Your Lordship,
now the petitioner
now,
have gone there? What
yes,
is his
now,
position? As of now, what is his position? What
now
is the
he is
position?
serving as a contingency.
Huh?
Now he is serving as on contingency. Your Lordship.
Understood. What happened to his application for compassion?
Yes, on the,
Thereafter, he filed one.
yeah, he actually filed, he also filed an application on the 16/7/2018.
Then-
So his serial number is appearing as serial number 3 on my affidavit in opposition, page 8.
Serial number 3.
Yes, Your Lordship. Page 8 of my affidavit in opposition.
What is his name?
Winnipeg, let's say.
Where is it? In opposition,
Respondent number 1 to 6, Your Lordship, filed by respondent number 1 to 6. In page 8, annexure B, Your Lordship.
He is
The petition is at serial number 3.
number 3.
Date of
No, no,
application.
this happened when? This is a long time old.
This was wrongly prepared.
Your Lordship, this is the list mentioned. That is the information that.
Have the 1 and 2 been appointed by now?
One is the.
So she has already been appointed. So
Yes,
now
Your
he's number 2.
The petition is at serial number 3 as per this.
No, 1 is have been appointed.
One already appointed respondent number 4.
So therefore, he's number 2.
Yeah, he will be a respondent. Yes,
So
serial number 2.
what happened to number 2?
Well, that they have to inquire.
Okay, you pick it up on Monday. Again,
Your Lordship, I'll make, if it
how
can,
we dispose of setting aside her appointment?
Your Lordship, if you can kindly accommodate me Friday because I'm having.
Next Friday?
This Friday, Your Lordship. Having inconvenience.
Or you want to do it on Friday?
Yes, I'll make an inquiry, Your Lordship.
I'm giving on Monday, council wants it on Friday. Okay, matter, let the matter be listed on 7/6/2024. On which date, Ms. Livika, the legal counsel appearing on behalf of the state respondent shall apprise as to what is the present position in the list of the, in the list at list of candidates for compassionate appointment, seeking compassionate appointment. In the list so prepared of candidates seeking compassionate